I can do what I want when I want to do it. I can do what I need when I need to get through it. When I need someone else, can't be too proud for help, but gotta look after myself. Sometimes it can get lonely, never living in the moment. When the sun is shining, hope that I'm reminded, like how the clouds keep changing. I'm always steady rearranging, going back to the basics of what a good day is. What a good day is. And that's exactly what the day is. But it's exactly what you make it. So please don't go wasting. And I'll do the same, even if it's raining. How could I complain? And my feels got me feeling some type of way. You always free to take a break. Hope you feel what I felt. You gotta look after yourself. Sometimes it can get lonely, never living in the moment. When the sun is shining, hope that I'm reminded, like how the clouds keep changing. I'm always steady rearranging, going back to the basics of what a good day is. Of what a good day is. What a good day is. And that's exactly what the day is.
All right, y'all know what time it is. Drop a 1 in the chat if you can hear me. Drop a 1 in the chat if you can see me. We're gonna go ahead and get into it. Hopefully everybody's doing well on this Tuesday morning. Shout out to the gang in the building. We got everybody up in here. It's all good. So good to see all of y'all, and thank you to everyone who dropped the 1s in the chat. We're gonna go ahead and get started. Let me see how we looking first though. Gotta make sure we're looking good. Everything's all nice. Woo, there we go. Looking all crispy and clean on the screen. Welcome y'all. Welcome back to another YouTube live stream and another episode of the Music Morning Show. I'm your host, Classy Beats at classybeats.com. And today we're going to get into some more news. We're starting day 2 of the ASAP Rocky trial. Got a lot we're going to get into. Of course, we got some motions hearing, and then hopefully we'll be able to hear some more testimony today and continue and finish the cross-examination that Joe Tacopina started on Friday. So we'll get into that. We're going to cover some other news. We've got some more updates on the YSL trial, some bad news for Lil Rod and Damon Blaylock. And then also we're going to go ahead and talk about Diddy to start out the show. But before I get into it, I got to say what's up to the people though. Shout out to everybody who's in here, man. Let me see who we got. I gotta make sure I get all the people in here. There we go. Of course, we have the awesome, amazing Amy is up in here bright and early. Shout out to Amy. We got Michi in the building. My dog Les Cleaver is in there taking home the big win last night on the Song of the Night Live. Alejandra's in here. We got Penny, Miss Verche. We've got my dog Rice Street. Shout out to Rice Street for calling into the show last night. Always a great time, man. Monterisa is in here. Axel. We got Axel Wheel up in here. Valencia is in the building. Galatians 6-7. Love that username. A Fitz is in here. Alabama GG. We've got Slim Life, Demetrius, Taco Tuesday. It's your day today. Olivia Rose, Jay Buckmaster, Queen Valerie is up in here. Ashley Linnell. We've got Serotonin. That's good to see you. Trish is in here. GG. Back at it. Sharice, Susan, Cindy White, Peter. Oh my gosh, Freedom Ring. We've got everybody up in here. John, salute, sir. And thank you for your service. Appreciate you being here. Who else we got? We've got Sabrina Grimes is in the building. And I want to make sure, I know I'm probably missed a couple of y'all. Young Steppa is up in here too. Shout out to Pastor Steppa. Aren't you supposed to be in school? Boy, Medico, get back at it, man. Stay in them books. We got Young Breed in here. Beth Davis, Kimberly Thomas. Good morning. We've got W Yo up in here. Daryl Davis. Good to see you. And then shout out to Slim Life in here. Just became a new member. Welcome to everybody on the member side. So many benefits to becoming a member. Most importantly, you do get access to the videos before we release them to the public. You guys get instant access along with a bunch of fun emojis that you can use in the chat as well. So make sure y'all check out the membership side and welcome Slim Life to the memberships. Also, we just started a brand new Patreon to celebrate 100,000 subscribers here on the YouTube channel. So make sure if y'all haven't checked it out yet, the link is in the pinned comment and also the pinned comment in the chat and also in the description. I'm dropping exclusive videos. We're going to have exclusive live streams over there, Q&As. We'll have live panels where you guys can interact. You'll get to come up on the show. And I'm also dropping exclusive interviews and content over there as well. Just dropped an interesting video from Fannie Willis that she allegedly was over there begging for money at an event. It's getting wild. So make sure y'all go check out the Patreon if you haven't yet. And we're going to get into it. Last thing I'll ask you before we get started, could you please make sure that you like the video on your way in? Not only is it free, not only does it help the show continue to grow, but it lets the YouTube algorithm know that you guys are enjoying the show and it shares the video with more people. So even if you're not watching on YouTube, wherever y'all are watching, please make sure that you like the video on your way in. All right, we're going to go ahead and get into it now. The ASAP Rocky trial is not going to start here for about another hour, but as y'all know, there's always something going on in the music community and the legal news as well. So we're going to talk about Diddy to start the show and see what's going on with him, because most recently, Diddy, of course, he's facing all the allegations he's been dealing with in this federal case. And of course, he's got 50-11 something lawsuits he's having to deal with now. He's got brought up again when it comes to what was going on in the case of Tupac and Biggie in some instances. We're going to get into that in a second. If you guys don't know what's been going on with Keefe D, he's currently incarcerated. A lot of history with Keefe D, Diddy, and obviously Keefe D is being accused of being someone who either orchestrated or was involved in the shooting of Tupac. The story goes, they were at a Mike Tyson fight. Tupac and Suge Knight were there, and then Keefe D and a couple other guys got into it with a relative of Tupac. Then they all left. After that happened, Tupac and Suge Knight were in the car. Keefe D and his boys decided that things weren't over with, and then they allegedly went after Tupac, and that's what happened to him, being shot. So now we fast forward a little bit. Keefe D is in jail. Believe the other two guys are dead. I know at least one of them is. And there's one of the guys that was involved. He's being accused of being the shooter. But Keefe D has a lot to say and has had a lot to say, not only through interviews on YouTube, but interviews and interrogations and testimony that he's given in court, trying to get out of this whole thing. Now he's saying that somehow Diddy was involved in this whole situation. And we're going to get into it here in a second. And again, if y'all haven't yet, make sure you like the video. Check this out from Law and Crime, and I'll leave a link to their full video in the description.
Now, at the time of Shakur's death, Combs was beginning his meteoric rise to the top of the rap world. He had started Bad Boy Records, now called Bad Boy Entertainment. And of course, there was this ongoing feud, West Coast versus East Coast, with this feud that he had with Tupac Shakur and Suge Knight, again, the leader of Death Row. So I want to take a look at the legal arguments that Davis's team had in their filing. And it reads, Defendant Dwayne Keith Davis hereby files this motion to dismiss on the basis that the state of Nevada has failed to timely pursue these charges against Mr. Davis, failed to provide corroborating evidence to support Mr. Davis's coerced confession, and failed to honor the federal proffer agreement between Mr. Davis and the United States government, thus substantially impairing Mr. Davis's constitutional rights. So two big arguments here. One is that the government waited too long to file the murder case, 27 years. They claim that this was done maliciously. By the way, though, typically speaking, there are no statute of limitations for murder. But even if they had filed the charges sooner, this is Davis's other argument, Davis says he's immune from prosecution thanks to an agreement he had with investigators when he was hauled in to talk about Tupac Shakur's shooting.
And keep in mind that Keefe D, he was being used as a type of informant by these organizations as well. So he was doing some talking.
And listen, remember, Bill Cosby, we all remember what happened to him. His conviction for drugging and raping a woman was vacated because his due process rights were violated, since a former DA had, in fact, made an oral promise to Cosby that he wouldn't be prosecuted. And remember, Cosby relied on that promise to admit some incriminating things about that encounter. So a high court actually determined his conviction should be thrown out. But going back to this, the first big interview that was referenced in the filing is from a couple of years after Tupac Shakur died. On July 16, 1998, Mr. Davis was interviewed by Assistant United States Attorney Michael Terrell. Mr. Davis's attorney, Mr. Eddie Fayol, was present. The interview was considered a proffer agreement between the United States government and Mr. Davis, under which any information provided by Mr. Davis would not be prosecuted related to that information. Mr. Davis was repeatedly questioned about the alleged murder of Tupac Shakur. Mr. Davis denied knowing who shot Mr. Shakur. Mr. Davis was asked to speculate as to who shot Mr. Shakur. Mr. Davis stated it was the Compton Police Department under the direction of Suge Knight, owner of Death Row Records. Mr. Davis was asked what would be Mr. Knight's motive, and Mr. Davis responded Mr. Shakur was getting ready to leave working with Death Row Records.
Yep, and that was mentioned in the chat. A lot of speculation going on because Tupac was about to leave Death Row, allegedly, and there was a lot of back and forth and a lot of issues behind that. Who knows what could have happened? I don't know if we'll ever know, to be honest.
At no time during the interview, less than 2 years after Mr. Shakur's shooting, did Mr. Davis state that he or members of Southside Crips were involved in any manner with the shooting of Mr. Shakur. Okay, goes to an issue of credibility. Well, Davis says he was interviewed again in 1999, and during that meeting, he denied that his nephew Anderson was the shooter. Mr. Davis stated that Mr. Anderson was not involved in the shooting of Mr. Shakur. Mr. Davis did discuss that Mr. Anderson was attacked by Mr. Shakur in Las Vegas the night of Mr. Shakur's shooting. Nevertheless, the decision was made to retaliate in Compton since there were so many police around in Las Vegas during the Mike Tyson fight. And during that interview, Davis blamed Compton police for spreading the rumor that Anderson had shot Shakur, although later we know that Davis himself would say that in public statements. But the motion to dismiss also says that Davis was offered immunity during the Biggie Smalls investigation in the early 2000s. The filing reads, the three LAPD and FBI agents were part of a task force to solve the shooting of rapper Notorious B.I.G., also known as Biggie Smalls, legal name Christopher Wallace. The task force, through a sophisticated criminal investigation, obtained sufficient evidence that would prove Mr. Davis was the leader of the Southside Crips and his gang was responsible for over 360 kilos of cocaine and PCP.
Sheesh.
Mr. Davis provided 3 interviews to obtain immunity from prosecution. The final interview were solely questions regarding the Tupac Shakur shooting, which Mr. Davis was also provided immunity from prosecution. So during a December 2008 interview with investigators, that is when Davis allegedly started to spill the beans about his one-time friend, Sean Combs, who we refer to as Puffy. He claims Sean Puffy Combs solicited Mr. Davis to kill Suge Knight and Tupac Shakur for $1 million. Eric Zip Martin, an associate of Puffy Combs, provided Mr. Davis with a gun to exact revenge on Tupac Shakur for the beating Mr. Anderson received. Now, Davis reportedly told the investigators that even though the job had been partially completed and Shakur was killed, neither he nor Anderson ever got paid. He later revealed that he believes Combs had paid the go-between Zip Martin, who he claims kept the money for himself. And he said much of the...
How do y'all feel about that? That story doesn't make sense to me. It doesn't make sense to me personally, because why would Diddy go out of his way to do that? Y'all have to let me know what you think in the comments and in the chat.
Same thing in a 2009 interview a year later, because according to the motion to dismiss, the Las Vegas Metropolitan Police Department, as far back as 2009, was in possession of the same set of facts that the Clark County District Attorney is now alleging makes Mr. Davis responsible for the murder of Tupac Shakur. The Clark County District Attorney's Office has offered no reason as to why it waited another 14 years to prosecute a case against Mr. Davis. Mr. Davis has been irreversibly prejudiced by this unnecessary delay in prosecution of this case, and Mr. Davis's constitutional rights have been violated in an extraordinary manner never before witnessed in the annals of the American criminal justice system. Now, of course, there was a response, because the prosecutors from Las Vegas called out Davis for being quite dramatic and said he has been telling on himself for decades. So their motion, in opposition to the motion to dismiss, states, in the years following Shakur's murder, defendant Dwayne Keefe D. Davis confessed to being involved in Shakur's murder in nearly every form imaginable. Defendant confessed to some of his role in Shakur's murder during an interview with LVMPD Homicide in 2009. Defendant admitted to seeking a deadly confrontation with Knight and Shakur in interviews with the producers of the Death Row Chronicles in 2017. Defendant...
That's crazy that he admitted all of this, but he since got immunity, so I guess it worked out.
Recounted his involvement in Shakur's murder in his book published in 2019, and defendant has gleefully claimed responsibility for the murder of Shakur in numerous YouTube interviews from 2019 up until his arrest. And the prosecution then addressed the issue of immunity from prosecution, right? Well, maybe he's admitting everything because, you know, he thinks he's immune. They have a response to that. Quote, defendant...
Y'all think Diddy did this because they were better rappers? I mean... I don't know. I get Tupac. He's eliminating the competition this way blatantly. I mean, Diddy was on his way up, though. Do y'all think that Tupac and Biggie were standing in Diddy's way? From a historical point, I can see that. I mean, Tupac, at this time, he was doing everything. I think Tupac was probably be looked at as Drake before he was Drake. But, I mean, what were they in the way like that, though? I don't know.
Asserts that he's received immunity from prosecution in this case. Defendant has provided absolutely no proof that transactional immunity was ever conveyed by any prosecuting authority. Defendant has provided no federal court order conveying immunity. Defendant has provided no California court order conveying immunity. However, even if he had such a grant, they couldn't possibly cover his criminal liability in Nevada. Defendant also claims that his proffer in 1998 and his statement to Detective Long somehow created immunity for the crime. As the court is aware, the legal community utilizes proffer to describe a contractual relationship between an interviewee and a prosecuting authority. In essence, a proffer agreement allows for statements made pursuant to the terms by the interviewee to not be used against that person. The state does not seek to utilize the 1998 proffer session against defendant and has no idea what the terms of such an agreement were between him and the federal government before he entered his plea. The report seems to reflect that this was a standard proffer where a criminal defendant is interviewed about his knowledge on all possible criminal subjects he may have information about before he's allowed to enter his plea. While he doesn't refer to the proffer agreement with AUSA Searwright, the terms of that agreement are known. Defendant was specifically informed that this agreement was between him and the federal government. Moreover, the agreement is limited to a single date and time. It allows for the statements to be utilized on cross-examination of defendant if he ever testifies differently. Finally, the agreement is limited by its express terms. Nothing in that agreement suggests that defendant has immunity from any criminal charges. Notwithstanding, it appears to only apply by its express terms to an interview on December 1st, 2008. Certainly, defendant is free to litigate the admissibility of the December 18, 2008 statement. However, case law establishes that defendant's mistake of fact about its admissibility, particularly where he had a lawyer present who knows the specific terms of the agreement, would not lead to suppression of the statement, meaning it can't.
And this is why I can imagine that state prosecutors specifically just cannot stand the federal government, especially when they step in like this, because you could have your whole case messed up, potentially, because the feds decide to grant someone immunity, which makes, we've seen Woody's immunity deal. I wonder if there's anything on the federal side. We haven't seen anything yet, but there's been some talks behind the scenes that Lil Woody may have had a couple of immunity deals. I don't know if we'll ever know that either. Yeah, Keefe D was doing a lot of talking.
Evidence. And on Tuesday, Clark County District Court Judge Carly Kearney agreed with the prosecution, saying Davis has provided no proof that he had any immunity deals. And we're going to expect to hear in the next few days if Davis's legal team plans to appeal that decision to the state Supreme Court. Remember, going back to Cosby, it was the Pennsylvania Supreme Court who ultimately determined that his conviction should be vacated because he had entered into an immunity agreement.
Right.
So we shall see what happens. Davis says he eventually became a confidential informant to a task force that was investigating the murder of Biggie Smalls. So this is Shakur's main rival at Bad Boy Records out in New York. And we know that Biggie Smalls was actually gunned down in Los Angeles. But prosecutors countered Davis's claims by saying there's no proof of any sort of immunity offer here, and that even if Davis had been offered some kind of protection from prosecution in California or the federal court system, that wouldn't apply to his case in Nevada. And the judge agreed, opting not to throw out the case, denying the defense's motion. One of the most interesting things to come out of that motion to dismiss, though, is just how many times Davis talked about Sean Diddy Combs over the years, the disgraced rapper and music mogul that we have been focusing upon a lot here on Sidebar, currently in a detention center on federal charges of sex trafficking and racketeering and prostitution, headed to trial out in May. But I want to talk about what Davis has to say about him. What he has to say about, I should say, Puffy. That's one of the many monikers that Combs has adopted over the years, and that's how he refers to him in this filing. So Combs started his meteoric rise to stardom in the early 90s as well. Started Bad Boy Records, now Bad Boy Entertainment out in New York. There was the big East Coast, West Coast beef, Death Row versus Bad Boy. And Davis says that Combs used that as an excuse to put out a hit, an assassination order on Tupac Shakur and Suge Knight. So let's take a look at what Davis had to say about Combs. And a little bit of note about this. So Davis has told many versions of his story to police over the years, changing some details, leaving other details out. Got to take that with a grain of salt about his credibility. Sometimes he would admit to things, sometimes denying them. Again, just take that for what it is. In fact, I will also tell you, the state talks about that in their opposition to the motion to dismiss, which says on December 18, 2008, defendant was interviewed by task force officers at his lawyer's office. This interview was surreptitiously recorded by LAPD Detective William Holcomb. During this interview, defendant confessed in detail about his involvement in the murder of Tupac Shakur, consistent with his book and subsequent YouTube.com statements. And
yeah, that's another That's another thing. He wrote a book and he was on the Art of Dialogue. I think just talking, man. Typical of somebody who has an immunity deal like this. Again, we've seen it in the YSL trial as well with Woody. I'll keep using that as an example. Once these guys get these type of deals, they're out there running, writing books, doing interviews, making money. Hey, snitches get riches.
What Davis revealed in an interview with the Art of Dialogue YouTube channel in 2021 is that his nephew, Orlando Anderson, shot Shakur from the backseat of the rented Cadillac. But during an interview with the FBI in 1999, Davis apparently said something completely different. According to the FBI report, which was included in the motion to dismiss, Anderson was not involved in the shooting death of Tupac Shakur, and neither Davis nor his group killed Shakur or Christopher Wallace, aka Notorious B.I.G. Davis does not know who killed the two rap stars. He believes that either individuals from New York associated with Puffy Combs or individuals associated with Death Row Records could have killed Shakur, and that individuals associated with Death Row Records killed Wallace. Okay, so again, changing stories. And by the way, Davis goes on to say that he was introduced to Combs in the early 90s by a man named Eric Zip Martin. This is another alleged drug dealer. And this is where we get into it. So the report reads, in or around 1992, Martin introduced Davis to Sean Puffy Combs. Davis recalls the introduction occurring at the Paradise nightclub on Santa Monica Boulevard. After speaking with Combs, Davis agreed to allow Combs to use his 1964 Chevy in a music video. The video featured the artist Usher. After the vehicle was damaged in the production of the video, Combs paid $2,500 to have it repaired. And by the way, according to Davis, Combs was scared of Suge Knight. And this was a man who had a reputation for being, sometimes violent and extreme. And that moves us now to this DEA report. So there was a DEA report from a 2008 task force meeting with Davis that was also included as an exhibit in the motion. And in it, Davis talks about the murder of a man named Jai Robles. This is Knight's bodyguard. He was killed in Atlanta in 1995. And according to Davis, he'd heard a rumor that an associate of Combs had killed Robles. The report says Combs requested to speak to Davis and asked Davis if he thought it was safe for Combs to come to Los Angeles for a concert. Combs expressed his concerns about Knight and possible retaliation related to the Robles murder. Davis advised Combs that he would provide 40 or 50 tickets to the concert. Davis could provide an entourage. Combs agreed, and Davis and his crew, in fact, attended the concert in support of Combs. Davis recalls the concert taking place in Anaheim, California. It was at this event that Combs began to solicit Davis to kill Knight and Shakur. Combs asserted something to the effect of, "I'll give anything for those dudes' heads." Quote, at a later date, Dwayne Davis, Eric Martin, Corey Edwards, Sean Combs, and others met at Greenblatt's restaurant in Hollywood. While at the restaurant, Combs summoned Davis into the downstairs area. Combs again told Davis that he needed to get rid of Knight and Shakur. Combs offered Davis $1 million to handle the problem. Davis remembers Combs being very afraid of Knight. So
yeah, I want to hear about Davis's and Diddy's relationship. All right, not like that though. Just why would he feel comfortable doing this? Because all the way up until now, Diddy's been seemingly pretty careful with how he moves. And why would you directly go to one guy to do this? It's like, hey, you want $1 million? Go Swiss cheese these dudes. And all of this is based on just testimony. Is there any evidence to surround it? I know they probably don't have text messages. Where is this coming from?
After the car that Knight and Shakur were in was hit by a hail of bullets back in 1996, Davis says that Combs wanted to know if that was the result of him allegedly putting out a hit on Shakur. The task force report states, well, at the restaurant, Martin told Davis that Combs had called Martin and asked, was that us? Davis asked Martin when he would receive compensation for the shooting. Martin told Davis he would get the money when he returns to New York. Additionally, while at the restaurant, Combs called Martin again. Martin then handed the phone to Davis. Combs again inquired, was that us? Davis recalled Combs sounding elated at the situation. Again, this is all allegations, but quite an allegation.
It's looking like he's about to start talking
told
too.
The investigators that even though the job had been partially completed and Shakur was killed, he nor Anderson ever got paid. He later revealed that he believes Combs paid the go-between, again, Zip Martin, who allegedly kept it for himself. So we mentioned a moment ago that an LAPD officer had recorded statements that Davis made in 2008. The state included a transcript of that interview in its filing. And in the transcript, WH refers to Wayne Higgins. This is Davis's lawyer during the interview. Q refers to the questions, and the A's are Davis's answers. Okay, so it says, WH, okay, now go on and ask whatever you want. Q, Puffy Combs. A, yeah. Q, does he play a role in this thing? WH, answer the question directly. Tell him what you think. A, did he play a role in this? WH, don't hesitate, just tell him. Question, yes. Answer, yeah, I think he did. And later in the interview, Davis said, yeah, I feel, I wish it would never ever, I wish I never met Puff Daddy, period, I swear to God. Question. Yeah? Answer. He messed up my life, man. I was rich up and under the radar, all that, man. Question. That's all gone? Answer. It's all gone. Now, what about Combs' alleged involvement in the death of Biggie Smalls, legal name Christopher?
Yeah, and he was rich because, he was running a sector of the gangs, in case y'all were wondering or didn't know.
Wallace, okay? This was a big one. Smalls was gunned down in a drive-by shooting out in Los Angeles in March of 1997. You might be saying, I thought they were friends, right? Anybody who followed this? We did a whole sidebar on this, but Gene Deal, a former bodyguard for Combs, who has recently started doing interviews and offering theories on Combs' alleged bad behavior.
Hey, y'all let me know how you feel about Gene Deal. This guy, this is again one of those dudes that's like, yeah, I was there. I saw everything. Yeah, I've been saying this about this guy, but didn't really do anything. Gene Deal to me seems like one of those type of dudes. I've heard a couple of the interviews and podcasts he's done. So I think he has a YouTube channel as well. Y'all could go check him out. But let me know how y'all feel about Gene and all the talking he's been doing.
1997. You might be saying, I thought they were friends, right? Anybody who followed this? We did a whole sidebar on this, but Gene Deal, a former bodyguard for Combs, who has recently started doing interviews and offering theories on Combs' alleged bad behavior, now says the rapper could have been involved in killing Biggie.
Oh, of course.
So Deal, who was reportedly Combs' bodyguard from 1991 to 2005, sat down for the documentary Diddy, The Making of a Bad Boy, that aired on Peacock. And according to him, Combs was acting weird in the lead up to Biggie's murder. He says in the documentary, the week in which Biggie was murdered, he was just acting real anxious and trying to get big at this party. And what was crazy was Big was telling people he had to be in London, but Puff was telling people he ain't going to London that whole week. You fast forward to the day of the party, and Deal says, I'm sitting up at the Beverly Hills Hotel, and I get a phone call. It's about 9 o'clock, and they say, Gene, get ready. We going to the Vibe party. I was like, we going to the party? We don't have no security. But according to Deal, tried to warn Combs this probably wasn't a good idea. I said, yo, Puff, I got some intel, bruh. He said, what? I said, yo, man, if we go to this party tonight, one of us is going to get killed. Somebody going to die because now we got East Coast, West Coast beef. He said, yo, Gene, I don't want to hear that S, so we all jump in the car. I was in a car with Puff. Big was in his own car. And the next thing you know, you hear pow, 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 pow. Biggie was shot 4 times, died right after arriving at the hospital. And according to Deal, Combs showed up at the hospital, seemed shocked that Biggie was dead. And we asked celebrity criminal defense attorney Brian McMonigal about this latest accusation against Combs, who's already facing these 3 federal charges related to the so-called freak-off activity. And again, he's facing dozens of civil lawsuits. But here's what Brian had to say.
I don't see this. This is a 30-year-old accusation.
I don't see it either.
And it seems to me that it's getting to a point where Diddy's concerned, where it's dangerously getting to piling on in a way that I think might just help him. As I thought about this last night, once I saw the article in the Post and was referenced on the documentary, it seems to me that there are a lot of people now that are jumping on this bandwagon of making what I would say are baseless allegations against.
And we've seen with all these lawsuits that's come out, some of them have been pretty solid. There's been a ton of evidence there. And most recently, as we've seen, a lot of them have just been total BS. It's like, this story doesn't make sense. This event didn't even happen. And now, as this attorney's saying, they're just piling on. And you got the Gene Deals out there like, yeah, I was there. I remember I saw this and I saw this. And you've got Mr. Davis up here like, oh, yeah. Or you got Keefe D's up here like, yeah. You know what? Now that I think about it, Diddy was involved. Come on, man. Let's not do that. What does Jennifer Lopez know? Oh, man.
It's this guy.
That's a good question.
This one in particular just smells to me. Did this guy say any of this stuff over the past 30 years to anybody in law enforcement? Has there ever been any kind of a suggestion that he was involved by law enforcement? It seemed to me that he was in a close relationship with Biggie, and that if anything, he was on the other side of this East Coast, West Coast fight. So
New York,
the one thing that I would say about it is just bringing this kind of full circle to this upcoming trial. They're going to be looking for things like this, the defense in this trial. They're going to be looking for accusations that are stretched. They're going to looking for moments that they can disprove things. And make no mistake about it, there'll be a few things like that. And hope that that'll give them the kind of strength and ability to diffuse perhaps as many of these allegations as they can where this indictment's concerned.
Now, to be clear about something, Combs has always denied any involvement in the deaths of Tupac and Biggie, and he certainly has not been arrested or charged in connection with their deaths in any way. As for Davis, we go back to him. It's going to be up to his attorneys to decide if they will appeal the judge's denial of their motion to the state Supreme Court. In the meantime, Davis has been denied bail, so he's going to be sitting in a Las Vegas jail until his trial, which is scheduled to begin in March. We'll keep our eye on it. Sean Combs' federal criminal case out of the Southern District of New York, where he faces charges of racketeering conspiracy, sex trafficking through force, fraud, and coercion of victim 1, and transportation to engage in prostitution. Trial currently scheduled for May 5th, 2025. I want to go back to the indictment because this is really where it centers upon it. So it alleges that Sean Combs and other members and associates of the Combs enterprise wielded the power and prestige of Combs' role at the Combs business to intimidate, threaten, and lure female victims into Combs' orbit, often under the pretense of a romantic relationship. Combs then used force, threats of force, and coercion to cause victims to engage in extended sex acts with male commercial sex workers that Combs referred to as, among other things, freak-offs.
Oh,
Freak-offs were elaborate and produced sex performances that Combs arranged, directed, pleasured himself during, and often electronically recorded. In arranging these freak-offs, Combs, with the assistance of members and associates of the Combs enterprise, transported and caused to be transported commercial sex workers across state lines and internationally. Freak-offs occurred regularly, sometimes lasted multiple days, and often involved multiple commercial sex workers. During freak-offs, Combs distributed a variety of controlled substances to victims, in part to keep the victims obedient and compliant. Sometimes, unbeknownst to the victims, Combs kept videos he filmed of victims engaging in sex acts with commercial sex workers. After freak-offs, Combs and the victims typically received IV fluids to recover from the physical exertion and drug use. Now let's
the victims part for adults, man, it just kills me. Y'all, some of y'all aren't gonna like this, but are we really gonna? These adults, the majority, I mean, there's alleged that there were minors involved. We haven't seen any evidence to show that. We're gonna talk about these adults being victims. It can happen, but saying that the majority of them or most of them were, I am not buying it.
Let's not forget that prosecutors allege that these freak-offs weren't just happening years and years ago. In one of their letters to the court, they wrote, indeed, since at least in or about January 2024, when the defendant was unquestionably aware of the criminal investigation, the evidence shows that he is engaged in multiple freak-offs, some involving the interstate transportation of individuals to participate, has continued to use narcotics, and has contacted multiple witnesses. Now, I think there's a fair argument to say that Sean Combs' defense counsel isn't going to shy away from the term freak-off. They might accept, yeah, Sean Combs called these sexual encounters freak-offs. Yeah, they weren't with commercial sex workers, but maybe it was group sex, or maybe it was things that were filmed with him and a partner of his, but doesn't make it illegal. The way it becomes illegal is if you do bring in these sex workers, if there is some sort of force or fraud or coercion that is used, or there are narcotics that are used, and this idea that it wasn't on the up and up. But I think they're going to say it might be different from what you and I do, but it's not necessarily illegal. I want you to keep that in mind.
They
and
were,
obviously, as you heard there are elements to the racketeering charge, this kind of idea that there was a criminal enterprise that engaged in all sorts of legal activity. Sean Combs was leading it. The sex trafficking, again, you particularly moving people across state lines for commercial sex acts. There has to be an element of fraud or force or coercion. Combs' attorneys filed a letter asking Judge Arun Subramanian.
And that's a key thing. And shout out to Jesse for pointing that out. There has to be some coercion. That's going to be a big part of this case. How were they coerced? Was it because it was this big, powerful music mogul and they didn't want to say no? Is that coercion there? Was there some type of deception? It's getting weird.
Prize that engaged in all sorts of legal activity. Sean Combs was leading it. The sex trafficking, again, you particularly moving people across state lines for commercial sex acts. There has to be an element of fraud or force or coercion. Combs' attorneys filed a letter asking Judge Arun Subramanian, this is the judge in the Southern District of New York who is overseeing this case, they are asking him to order the prosecution to electronically produce videos of the freak-offs to the defense. And the reason they want these electronically produced, the reason they want copies of these in their possession to review and analyze, and why they need the court to step in, is because they say that under the current protective order in this case regarding how evidence will be viewed and disseminated, the video evidence is available for inspection only. Right? They have to go to a certain place provided by the prosecution in order to view these videos. They say that's not fair. And according
and we talked about this too, because there are 9 videos that the defense saw, and they said they wanted to be able to have these electronically so they don't have to go back and forth. And they also said in these 9 videos, allegedly Cassie is in either all of or a majority of them, that she didn't look like she was coerced. Let me just put it that way. So we'll have to see that happens. I guarantee you, I would bet everything I have on the fact that if these are available electronically, if these freak off videos become available electronically, they'll be leaked. It's 100, 1,000 million% gonna happen.
According to the defense, the federal prosecutors refuse to produce over these videos to them. But
They
more
said
importantly,
nope.
and this is the key, Combs' lawyers write, we need these videos because they prove our client is innocent. Quote, having reviewed these videos, it is now abundantly clear that they confirm Mr. Combs' innocence and that their full exculpatory value cannot be investigated and used unless they are electronically produced. The 9 videos at issue are the so-called freak-off tapes with victim 1 that the government has repeatedly referenced, causing wild speculation in the media. Contrary to what the government has led this court and the public to believe, the so-called freak-offs were private sexual activity between fully consenting adults in a long-term relationship. Like many Americans in the privacy of their own bedrooms, they sometimes filmed their sexual activity. These videos unambiguously show that the person alleged in the indictment to be victim 1 not only consented but thoroughly enjoyed herself. And we believe victim 1 to be Cassandra Ventura. This is Diddy's ex, who first filed that initial sexual assault lawsuit against Combs back in 2023. She was also in that infamous surveillance footage that was published by CNN months ago, where you see Sean Combs in a towel beating Cassandra Ventura, dragging her, kicking her. The filing goes on to say, quote, moreover, contrary to innumerable sensationalistic media reports, the videos do not depict sex parties. There are no secret cameras, no orgies, no other celebrities involved, no underground tunnels, no minors, and not so much of a hint of coercion or violence. So not only talking about the allegations in the indictment, but also...
Thank God there were no minors in these videos, because I was about to... We don't play with that over here.
All of the claims that have been made in the media as well. Now, far from the government's lurid descriptions, the videos show adults having consensual sex, plain and simple. At bottom, this case is about whether victim 1 was or was not a willing participant in her private sex life with Mr. Combs. The videos confirm that she plainly was. And the defense, in this letter, describes victim 1 in these videos as, quote, happy, dominant, and completely in control. They write there is no evidence of any violence, coercion, threats, or manipulation whatsoever. There's no evidence that anyone is incapacitated or under the influence of drugs or excessive alcohol consumption. There is certainly no evidence of sex trafficking. That's what they say. They go on to write, the premise that freak-offs are inherently dangerous shows that the government seeks to police non-conforming sexual activity and that it assumes, despite all evidence to the contrary, that a woman's willing participation must have been coerced. So again, that idea of doesn't seem like they're shying away from these freak-offs, but saying, while the freak-offs might be unusual, they're not illegal. Now, the defense also says that they reviewed photographs that they say victim 1 allegedly sent to Sean Combs, and they too appear in their characterization, quote, to reflect entirely consensual sexual activity. And the defense also claims in this letter that these recordings corroborate what witnesses have told the government. And they don't really explain more about that, but that seems to suggest that these witnesses are going to be helpful to Sean Combs' defense. Maybe these are sex workers who were there and say, look, our opinion, Cassie consented to everything that was going on, or victim 1 consented to everything that was going on. Now, we actually spoke with criminal defense attorney Bradford Cohen about this, and he's represented celebrities like Drake, Lil Wayne, Kodak Black. And the question is, based on the defense's characterization, is this the end of the prosecution's case, right? Do these videos prove that Sean Combs is innocent? Is there anything more? Take a look.
I think it's interesting because, you know, from the very beginning of this case, I was saying, I think that the original tape showing the violence against Cassie, I think the original tape was leaked by her team to show that she is a victim and not a willing participant or a co-defendant. So I've been saying that for a long time. So to hear this, we've seen these 9 videotapes, and these 9 videotapes kind of back up what we've been saying the whole time, that it's consensual sex between adults. It's an interesting thing to say, because I think that the videotapes are going to show that Cassie probably was engaging with another individual. The videotapes are probably going to show that it wasn't a hidden camera, maybe that she was making faces or saying something to the camera that confirms that it wasn't a hidden camera or someone's talking on camera. All those different things definitely help his case. Is it a smoking gun, as we say? No, probably not a smoking gun, because she's going to still say, listen, I was still under the control of Sean Combs. He was physically controlling me. He was mentally controlling me. That's going to be where she goes with this whole thing. And that's where that tape of violence comes in, to show that, yeah, it might have looked like I was doing these things on video, that I was a willing participant. But in reality, I knew if I was not a willing participant, then something else would have happened to me physically or mentally.
Now, you might be saying, well, look, the fact that the tapes exist, Jesse, that shows that Sean Combs is guilty, because the government alleges he secretly filmed these encounters and used it to blackmail victim 1 to stay silent, to do what he wanted. The defense, to do what he wanted. Well, the defense has an answer to that in their letter. They write, these recordings were not on Mr. Combs' devices and were not seized from his homes. Rather, victim 1 kept these videos on her own device for years and produced them to the government herself. Now, Bradford also had an interesting take on that as well.
If the defense had these tapes, or Sean Combs had these tapes, when the tape came out, or when the accusations came out, that she was not a willing participant in this sex, you don't think those tapes would have been leaked? Like,
Well,
that
he would
been
have
the
gotten in a
first
lot
thing.
of trouble if he did that, right?
Well, before the charges
No,
were even
not
filed.
necessarily.
When she said, when she first
Should've
hit
leaked
him
them.
with the civil complaint, and in that civil complaint says she was not a willing participant, she was not involved in these things, all these different kind of accusations in that civil complaint, you would at that point say, what are you talking about?
He settled with her the next day. And if you're him, I don't want to release these videos of me, my private sex life. He probably didn't want to.
No, but you could, there's a way.
Yeah, you think about it too. At the same point, Cassie, and obviously, let's be real, her team released that video of her getting kicked up and down the hotel hallway, right? You have to ask, other than the obvious, why they wouldn't want these other videos released. If she was a victim, like they say she was, and like the federal government's going to try and prove, then why wouldn't they release some of these videos too? It makes you wonder what's in there. I hope they never get released. Oh my God. I hope they never get released. And if they do, I won't be watching them. But y'all have to let me know what you think about this in the comments and in the chat. Interesting stuff, especially when it comes to Keefe D. I don't know what Diddy's going to do about that. We'll see what happens moving forward. Shout out to everybody that's in here too. We got over 800 of y'all up in here, and over half of you have liked the video. Thank y'all for liking the video. I appreciate the love and support. Y'all are talking about the case on this one. Coercive control is a chargeable offense in the UK. And before anyone come for me, I was born in Jamaica, raised. Oh, okay, I see. Rice Street says it wasn't a consensual swooping though. I mean, maybe it was. We don't know. Allegedly, right? We don't know. We don't know what type of thing they were on. I mean, I'm not going to get into that again today. We've got another topic we were going to get into. And again, y'all, court is going to be starting here in about 15 minutes. And then we're going to get back into the day 2 of the ASAP Rocky trial. So I've got one more article we're going to get into, and I want to hear what y'all think about this too, because this one is interesting. So we're a little bit, I should say, somewhat removed from the YSL trial. It seems like things are kind of winding down a little bit when it comes to everything that's going on. And I want to go, well, we'll do it this way. Let me pause this real quick. Yeah, we'll go back. We'll talk about the Diddy thing later. I see y'all in the comments. Either way. So recently, well, not even recently, and thank you to Cat Not Williams for sharing this. I will leave a link to the full document we're about to review here shortly. But if y'all remember, Brian Steele, he represented a couple of the defendants in the YSL trial, and one specifically that was severed completely from the YSL trial, which was Damon Blaylock, or they call him Bali, right? And Brian Steele had to go to the Supreme Court, and he had to argue for his client because he was being held, and he's facing life in prison for a shooting that took place in 2019. And we're going to get into that in a second. So Brian Steele went before the Supreme Court, made his case saying he shouldn't be held in life. It shouldn't be held in prison for life. Brian Steele was also talking with some of the other defendants, and we know Lil Rod was included in that argument as well. Now we've come to find out today that the Supreme Court actually upheld their decision when it comes to Lil Rod and Damon Blaylock, which is it's unfortunate for them because it's looking like they're going to spend the rest of their life in prison. Now, going back and rewinding a little bit, both of them were actually indicted on the original YSL trial for RICO charges, and that's all they were indicted for. It was just count 1, which was the RICO. Eventually, for Mr. Blaylock, those charges were dropped, I believe, in October. And then for Rodelius Ryan, aka Lil Rod, he actually got a deal out of that as well. And I want to go back and review the video when he took his plea deal, and so that y'all can get just a good reminder of actually what went down there.
All right, thank you. And Mr. Ryan, I just want to make sure that you understand that this is ultimately the decision is yours to make, not your attorneys, and I appreciate that both Ms. Abbasi and Misty Williams have been available in giving you legal advice and guidance, but it's ultimately your decision. Do you understand that?
Yes, ma'am.
All right. And do you, in fact, want to plead guilty?
Yes, ma'am.
All right. And you've had enough time to think about it and to discuss it with your attorneys?
Yes, ma'am.
All right. And Ms. Abbasi, have you and or Mr. Williams talked to Mr. Ryan about the benefits and drawbacks of all of his different options?
Yes, Your Honor.
All right. All right.
Yeah, it was bad.
Find that there is a factual basis for the guilty plea to count one, the conspiracy to violate the RICO Act. Whatever the difference of opinion may be with regard to what YSL is or isn't, and what Mr. Ryan may or may not have intended, there is a factual basis that exists from the record, as it already is in this case, to support the necessary elements of the conspiracy to violate the RICO Act. And I have heard many of the alleged overt acts and the conspiracy evidence to
I agree,
advance the enterprise through a pattern of racketeering activity and to control personal property and money. And I find that the factual basis for that exists. And I am going to accept Mr. Ryan's guilty plea. I find it to be freely, knowingly, intelligently, and voluntarily entered with an understanding of the consequences of this plea. And I'm going to sentence in accord with the recommendation that both of the state and the defense have worked hard to negotiate here, which is a sentence of 10 years commuted to time served and to be run concurrently with the sentence that Mr. Ryan is currently serving. And certainly within the court's consideration is the knowledge that Mr. Ryan is at this time serving a life sentence for the murder of Mr. Holmes. And while I understand that that is on appeal right now, those are the facts as they exist right now. So that is the sentence of this court. Mr. Ryan, at 20 years old, you have most of your life ahead of you, and I don't know what it is going to hold with regard to your appeal or anything after that. But whether it is more years in custody or whether at some point in time you see the light of day to the outside world again, which is very likely considering your age, as long as you behave yourself while you're incarcerated and do not continue
That's asking a lot,
to
Judge Whitaker.
either commit crimes in prison or violate any of the prison rules. If you can be on the straight and narrow, then somebody your age, after serving some amount of time, is probably going to be considered favorably for parole. And you just have to keep that in mind, that you need to be looking out for sort of the long run and not playing the short game, but playing the long game so that you have a future in front of you still. So that is your sentence, and I wish you luck, and I wish that with further maturity, much like Ms. Abbasi has said that you have already exhibited throughout the course of this trial, that you are able to make better decisions and steer your life in a better direction.
Yeah, and that was tough, man. So that was Lil Rod getting a tough sentence from Judge Whitaker. He got 10 years commuted to time served. So, and obviously he's still doing life, which it's looking like, according to this document, it's not going to go away anytime soon. So let's get into this from the Supreme Court. What do they say? Appellates Damon Blaylock and Rodelius Eugene Ryan, Lil Rod, were convicted for the malice murder of Jamari Holmes, the aggravated assaults of two other individuals, and other related crimes, which they list out here. I'll go ahead and read them. The crimes occurred on February 23rd, 2019. In May of 2019, a Fulton County grand jury indicted the appellates for participation in criminal street gang activity on count 1, which one was found guilty for, the other, the charges were dropped. Malice murder, count 2. Felony murder, counts 3 through 5. Aggravated assault with a deadly weapon, counts 6 through 8. Criminal damage to property in the first degree, count 9. And possession of a firearm during the commission of a felony, count 10. Counts 1 through 5 were bifurcated for trial. Ultimately, those counts were not presented to the jury and were null pros. Appellants were tried together before a jury on September 21st to October 1st of 2021, and the jury found the appellants guilty of all presented accounts. The trial court sentenced appellants to serve life in prison on count 2, 10 consecutive years on count 7, 10 consecutive years on count 8. Oh my gosh. 10 concurrent years on count 9. That's okay. And 5 consecutive years on count 10. The remaining counts merged or were vacated by operation of law. So we're going to count these real quick. So what did they say? Life in prison. They've got 10. So life plus 10. Another 10, that's 20. Okay, that's concurrent, so we're good. Plus 25. The remaining counts merged or were vacated by law. Oh my goodness. Appellants each filed timely motions for new trial, which were amended several times through their new counsel. Following hearings, the trial court denied the amended motions on May 20th, 2024. Appellants filed timely notices of rendered ineffective assistance in several ways. We also review whether counsel's alleged deficiencies, when viewed cumulatively, require reversal of his convictions. For the reasons that follow, we affirm. Viewed in the light of the most favorable to the jury's verdicts, the evidence presented at trial showed the following. On the day of the crimes, the appellants, Ty Hartfield and Mariah Smith, were at Blaylock's apartment. Hartfield invited Bernard Mitchell, Rodney Uten, and Jamari Holmes, the victims, to meet up with her and Smith. So basically they were trying to set these dudes up, is what was alleged. When the victims arrived, Hartfield and Smith got into the victim's car, and Hartfield directed them to go to a nearby apartment complex where Ryan resided to buy some weed. Upon arrival, Mitchell parked his vehicle. The victims gave money to Hartfield, who exited the vehicle to purchase the weed. Hartfield returned a few minutes later and told Smith to come with her because somebody needed to see her. Smith got out of the car, and when she reached the apartment stairs, heard gunshots and saw appellants shooting at the victim's car. So she saved her, which is crazy. Neither Mitchell nor Uten saw the perpetrators clearly enough to identify them, but both told police they saw a shooter who was tall with dreadlocks come out of the apartment in Breezeway with an assault rifle shooting at the car. Mitchell also told the police he saw another shooter at the corner of the building, though Mitchell did not recall seeing a second shooter at trial. Mitchell and Uten fled on foot after Mitchell's vehicle malfunctioned. Smith and Hartfield hid nearby until Ryan picked them up, and they returned to Blaylock's apartment. When officers arrived at the crime scene, they found Holmes, who had been shot in the back of the head, in the passenger seat of the victim's car, which had several bullet holes in the exterior. Holmes was taken to the hospital and died shortly thereafter. So he was still alive when they got there? Oh. Investigators determined that the fatal bullet entered through the rear of the car, pierced the back seat, and exited through the front of the passenger seat where Holmes was sitting. A 7.62 millimeter bullet fragment was recovered from Holmes' head during the autopsy. At the crime scene, officers recovered a 7.62 millimeter shell casings and a 9 millimeter shell casing. Ballistics tests showed that all the 7.62 millimeter casings were fired from the same gun, most likely a rifle, and all 9 millimeter casings were fired from the same gun, most likely a pistol. Investigators determined that the 9mm rounds were likely fired from the corner of the building close to the victim's vehicle, consistent with Mitchell's initial account of where the second shooter appeared. After fleeing, Mitchell and Uten called Hartfield and asked, "Why are they shooting at us?" Hartfield replied, "They said that y'all parked in front of the spot." Hartfield then texted Mitchell claiming, "We did not set you up." Mitchell and Uden reported Smith and Hartfield's potential involvement to the police, and shortly thereafter, officers located and interviewed the two women. The interviews were video recorded and were admitted into evidence at trial. Although Smith initially refused to admit that she saw Appellate's shooting at the victims and instead provided several alternative accounts of the crimes, she ultimately admitted to seeing the Appellate shoot at the victims. Dang, man. No, I'm not even going to say that. In contrast, the lead investigator testified that Hartfield was not cooperative during her interview and did not provide any information what happened at the incident. I believe, if I remember correctly, Detective Hogan was the one, or was the lead investigator on this. If I remember, y'all have to let me know. I know y'all will remember in the comments and in the chat. I believe it was Hogan who was the one that investigated this. After her interview with the police, Hartfield messaged appellants on Instagram that she stayed solid and told the police that she did not know what happened, but that Smith was snitching, so the police knew about Blaylock, but not Ryan. Blaylock replied that he knew that Smith was a rat and asked what Smith said about him. He must have been getting some phone calls. And y'all are saying, yeah, it was it was Hogan. Oh, God. At trial, Mitchell, Uden, Smith, and Hartfield testified for the state. Smith's explanation of events at trial aligned with the victim's testimony of what took place, threw him all the way under the bus at the crime scene. That is, that the victim picked up Hartfield and Smith from Blaylock's apartment. Hartfield directed the victims to the scene of the crime. Hartfield exited the vehicle before returning to retrieve Smith. Then shots were fired at the victim's vehicle. Smith also specifically testified that she saw the appellates fire their weapons at the victims and explained that she initially lied during her interview with police because she feared retribution by the appellates. That makes sense. During Hartfield's testimony, she invoked her right against compelled self-incrimination numerous times because, although not charged in connection with the case, she was under indictment for other charges at the time of the trial. However, Hartfield also provided some substantive answers, such as denying that she knew Ryan, denying setting up the victims, and denying directing appellates to shoot the victims. Well, you can't deny. There's no denying that. Appellate's theory of defense was that neither appellate was present during the crimes. Throughout the trial, appellates implied that Hartfield and Smith were shielding the real perpetrators. Blaylock argued in his opening that the reasons appellates were on trial was because Hartfield and Smith don't want to tell what really happened. To that end, appellate sought to persuade the jury that the state failed to present sufficient evidence to prove appellate's guilt beyond a reasonable doubt by highlighting Smith's shifting accounts of the crimes and Hartfield's invocation of her right against self-incrimination. She pleaded the fifth. For example, during closing, Ryan explained that the problem with Hartfield's invocation of her right against self-incrimination was that her silence didn't really help the jury figure out what happened. Both appellates contend that the trial counsel rendered constitutionally ineffective by ineffective assistance by one, or A, failing to object and move to strike Hartfield's testimony after she invoked her right against self-incrimination in the jury's presence, and failing to object to the trial court's charge on how the jury should access Hartfield's invocation of that right. B, failing to review and introduce certain evidence that would support appellate's defense. And C, not objecting to each of the prosecutor's comments on the appellate's silence during the closing arguments. Ryan separately argues that trial counsel was ineffective for failing to investigate his alibi. We address these arguments in turn. Okay, what happened? To prevail on a claim of ineffective assistance, appellants bear the burden of showing both the trial counsel's performance was professionally deficient and that they were perjured as a result of the performance. And then they cite this case here, Strickland versus Washington. The burden was not this burden, though not impossible to carry, is a heavy one. To show deficient performance, appellants must demonstrate that counsel performed at trial in an objectively unreasonable way, considering all the circumstances and in light of prevailing professional norms. Yeah, well, that's going to be tough to prove here in Fulton County. It seems like it's a normal occurrence. Our inquiry focuses on the objective reasonableness of the counsel's performance, which we evaluate in conjunction with the attendant circumstances. Okay, and then they cite more case law there. Thus, the deficiency cannot be demonstrated by merely arguing that there is another or even a better way for counsel to have performed. They did their job. All right, so we'll skip through some of this. To show prejudice, the appellants must establish a reasonable probability that in the absence of counsel deficient performance, the result of the trial would have been different. Again, you're not going to get away with that here in Fulton County. They're going to let it roll. In their first claim of ineffective assistance, appellants challenged trial counsel's performance with respect to the counsel's handling of the following series of events. Before Hartfield testified at trial, her attorney indicated that Hartfield would invoke her right against her Fifth Amendment, right? To the Fifth Amendment of the federal Constitution. I don't know why they say it that way. Outside the jury's presence, the trial court discussed at length Hartfield's anticipated testimony with the parties and Hartfield's attorney, as well as the types of questions to which Hartfield could potentially respond without incriminating herself. The trial court emphasized several times that the parties agreed that Hartfield could not refuse to respond to questions that would not elicit incriminating responses. The state ultimately called Hartfield to testify. On both direct and cross-examination, Hartfield invoked her right against self-incrimination numerous times. Though she provided substantive responses to some questions, appellants raised no objection during Hartfield's testimony to her invoking her right against self-incrimination. Just like the judge said in the A$AP Rocky case. Why are you bringing it up now? During closing arguments, counsel relied on Hartfield's silence to argue that the state failed to present sufficient evidence to prove appellate's guilt beyond a reasonable doubt. During deliberations, the jury submitted the following question to the trial court. How shall we interpret pleading the fifth? After both the state and the defense counsel assisted in crafting a response, the court instructed the jury as follows. Okay, basically, they did their job again. So we're going to keep it moving through this and go to, give me 1 second, this section. Let me find the next section. Basically, this is the Supreme Court saying that they did their job, they followed procedure, and that was fine. All right, let me find this other section. Hold on a second, y'all. Here we go. We want to get to the Instagram messages. So we've got... Okay, here we go. We now turn to the appellate's argument that the trial counsels were deficient by failing to object to the trial's response to the jury's questions because they assert it improperly authorized the jury to draw inferences from Hartfield's invocation of her right, pleading the fifth, that were adverse to appellants. But as we have already discussed, the record reflects that during the closing arguments, the trial counsel sought to capitalize on Hartfield's invocation of her pleading the fifth as a part of their theory of defense, repeatedly pointing out Hartfield's silence as demonstrative of the state's failure to produce sufficient evidence to prove appellate's guilt. In light of that closing argument, it was not an objectively reasonable strategy to forego objecting to a jury's instruction that permitted the jury to factor Hartfield's silence into its deliberations in hopes that the jury would view the lack of testimony from a key witness as to what happened on the night of the crimes as an indication that the state had not presented sufficient evidence to prove the case. All right. Thus, under the circumstances of this case, we cannot say that the trial counsel's decision to forego objecting to a jury instruction that could have benefited the defense was objectively unreasonable. All right, and they cite some more cases there. Okay, so we're going to skip this. Although Mrs. Mitchell's message about shooting back may cast doubt on some of the state's evidence, we cannot say that introducing the evidence would have created a reasonable probability of a different outcome. And then they give an example here, Lee versus State. First, given that Mitchell claimed to have fired back to the text messages, in fact bolster evidence that shots were fired from outside of the vehicle first. Interesting point. Second, the messages do nothing to undermine other strong evidence that the fatal shot came from outside the car. So what are they saying? It was in self-defense? Investigators determined that the fatal shot entered the rear of the car, pierced the back seat, and exited through the front of the car seat where Holmes was sitting. Further evidence showed that the fatal 7.62 millimeter bullet could not have been fired by a .22 caliber gun, which was the caliber of the weapon that Mitchell admitted was on his person at the time of the shooting. Third, even if Mitchell's messages were presented to the jury, and we assume the jury would have credited them, the messages do not definitively prove that there had only been one person shooting at the victims, as appellants claim. Yeah, and there were 9mm and 7.62 shell casings found. So that's going to be a problem. Appellates appear to reason that the ballistic evidence presented at trial showed there were only 2 guns used at the crime. Therefore, Mitchell's message would show that there was at least one victim shooting from the car, accounting for one of the guns, leaving only one shooter outside the vehicle firing the other gun at the victims. However, the state's ballistic expert testified that at least 2 different guns were fired, but explicitly clarified that he could not testify that only 2 guns were fired. Accordingly, appellate's arguments that Mitchell's messages would have conclusively dispelled the state's theory is inaccurate. Given these circumstances, appellates have failed to establish a reasonable probability that the result of the trial would have been different had trial counsel reviewed and introduced into evidence the Instagram messages, and thus have not shown the requisite prejudice to support their claim of inefficient assistance. So that's one of the reasons. Another reason, during closing arguments, the prosecutor acknowledged that the defendants carry no burden, but urged the jury to listen for the appellate's explanation in response to the following question. If the defendants were not committing the murders, where were they? Appellates objected to the comment as burden shifting, but the trial court overturned the objection. The prosecutor repeated the question, emphasizing that the defendants are both saying they weren't there. Tell us where you were. Yeah, that doesn't make sense, because even the messages that they wanted to introduce, didn't they say that they were there? It seems like they're trying to go in the circle here. We didn't hear any evidence of it, obviously, but I would still like to hear that answer. Blaylock again objected to the statement as burden shifting. The trial court sustained the objection and instructed the jury. Tell us where they were should be disregarded. In his rebuttal closing, the prosecutor returned to the same theme. I wanted to hear the answer to the question, if they weren't committing the murders, where were they? The prosecutor continued to ask, at any point, did you hear an answer to the question? I did not, because they can't answer it. Because the answer is they were committing this murder. Dang. The prosecutor continued, the defense does not have to call a single witness or present a single piece of evidence in this case, but they can if they have it. But they didn't, because they don't have it. Golly! Trial counsel did not object to these comments. Oh, man. Oh, man. That's tough. Oh, man. Whether the trial counsels were deficient by failing to object to each of the prosecutor's purportedly improper comments, appellants have failed to establish the requisite prejudice in light of the strong evidence of their guilt, including Smith's testimony identifying them as the shooters, the victim's testimony that corroborated Smith's account of the crimes, and the inculpatory messages sent between appellants and Hartfield. Yeah, you can't get away from that. That's going to be tough, man. Here, trial counsel testified at the motion for a new trial hearing that he was unaware of the potential alibi defense, but elected to not pursue it any further after he conducted a mock examination of Ryan, which did not go well. Counsel testified that he did not believe an alibi defense would be persuasive unless Ryan testified, and also noted that evidence at trial contradicted the purported alibi. Counsel instead thought it would be better to argue that there was only one shooter and that the other shots came back from the alleged victim. As a result, counsel elected not to investigate the alibi defense any further. Given the conflicting evidence and counsel's objectively reasonable concern about the strength of an alibi, we cannot say that the counsel's strategic decision not to investigate and present Ryan's alibi defense was unreasonable. See Smith 308GA at paragraph 9 through 92. Claimed that counsel was ineffective for failing to investigate and present alibi defense failed where a witness placed defendant at the crime scene, and counsel believed that an alibi present by the defendant's girlfriend would not be persuasive. Accordingly, this claim fails. Finally, we consider whether the combined prejudicial effect of the trial counsel's assumed deficiencies warrants a new trial. See Schofield versus Halsey, maybe. Overruled on other grounds, State versus Lane. In our review of the appellate's claims, we assume that counsel were deficient for failing to review and introduce into evidence Mitchell's 2 Instagram messages and failing to object to each of the prosecutor's comments on silence and closing arguments. All right, and then we get to the end. As discussed in Division 2, B, and C, counsel assumed failures are unlikely to have affected the outcome of the trial, and we do not see that the prejudice from these 2 deficiencies would culminate in any way to cast doubt on the verdict. And they say this claim therefore fails. Judgments affirmed. All justices concur. Dang. So y'all have to let me know what you think about it. It's a sad day for both of these guys. Moving forward, it seems like they're going to have to keep their nose clean and try and see if they can get out on parole. I don't know what's going to happen. You'll have to let me know what you think in the comments and in the chat. And it looks like it's time for the ASAP Rocky trial. So we've got, are we going to give him a name? I think we should, we need to respect his name. I don't know what the judge's name is, so we're going to call him the Honorable Colonel Sanders. They wanted the charges to be dropped on that one, but that didn't happen. So let's get ASAP Rocky back up in here, and we're going to go ahead and get into trial and see what the Honorable Judge Sanders is talking about. Here we go.
Mayor's matter.
Orville Redenbacher. Judge Popcorn.
Efron, also known as
and y'all like the video if you haven't yet.
ASAP Arelli is going to be called to the stand today. Is that right?
That is the plan, yeah.
All right. Arelli is, I know, a very important witness to both sides.
Your Honor, just so you know, he's in the court right now. I didn't mean to cut you off, but I wanted to make it aware.
Where is it?
So from what I understand, we're going to start with motions, but we may go straight back into cross-examination. We'll see.
All right. Mr. Efron is an extremely important witness to both sides. That's patently obvious. The jury is entitled to know him and about him, consistent with case law and statutory law. The parameters of questioning that I am permitting is based on my consideration of a number of factors, including the evidence code, specifically all aspects of evidence code section 352, the probative value weighed against prejudice, the relevance to issues that the jury will have to decide and discuss, and both sides advocating for their client, and above all, fairness to both sides.
What are we talking about, Judge?
The rulings on what Mr. Efron can be questioned about on direct examination and cross-examination is final, with no input from either side. He can be called, he's been identified as ASAP Relly. He's also been identified as Terrell Efron. Depending on how you wish to address him, you can call him either Relly or Mr. Efron.
Is Relly testifying today?
Not to be asked any question that asks of him. Oh, and I mentioned, I had told counsel before that they could record what I'm saying now for future, in the future, for later today or any other time. And the people are welcome to also. We have one more thing. Oh, you.
Damn, we're getting Relly on the stand this early.
All right, I'll start again. As I said, he can be called by both parties, either Relly or Mr. Efron, whatever the counsel feels most comfortable with. He is not to be asked any question that asks of him or accuses him
Of the lawsuit.
of being a thief, a liar, an extortionist, or any other derogatory term.
Yeah, but they can say it.
He's not to be accused of any type of name. Final argument is a different story. This only applies to how he's going to be addressed. I don't want, well, isn't it true you're a liar, or, you know, you're an extortionist, or, you know, are you a drug dealer, or anything like that. That is not to be asked. He can be asked about felony convictions involving moral turpitude. I have not seen a rap sheet of Mr. Efron. Does Mr. Efron have any felony convictions?
No.
So if he has
ASAP
no
Parasite.
felony convictions, obviously he has no felony convictions involving moral turpitude.
I agree.
And you reviewed his rap sheet?
I did.
Listen, y'all gonna kill me for for interrupting this, but it doesn't matter about his past. It doesn't matter. This man sent ASAP Rocky a picture of the cell case. He's like, I'm gonna be rich. It doesn't matter. Like, throw all that away. He could have ran over a baby, intentionally ran over a baby and a puppy in his driveway. It would not matter in this case. He's a scum. He's a liar. We've seen the evidence. Come on, man. Anyway, we'll keep it going.
I had written in my notes here that if he has felony convictions, I wanted to review his felony, review his rap sheet.
The jury's going to
before
see
he
that
testifies
easily.
under Evidence Code Section 352, but if he has no felony convictions, then there's no reason for you to examine a rap sheet, even assuming he has one. He is not to be asked about any other involvement in any other criminal activity in which there was no felony conviction. All of that is off.
Like planting evidence.
So if there has been illegal conduct in the past, if it did not result in a felony conviction involving moral turpitude, it's off limits. The relationship between Rocky and Relly is fair game. All personal contact between Relly and Rocky from the date of the shooting to the present is fair game. any statement by Relly to anyone regarding his seeking money from Rocky, both pre-incident and post-incident,
Is
fair game.
oh, Relly's gonna get cooked. Judge just said anything that this man said about getting money from somebody is fair game. Boy, oh my
Any
gosh.
personal contact between Relly and Rocky of any kind which
Cooked.
predate the shooting by 2 years is fair game.
Dang.
Statements made by Relly to anyone
Oh my
about
God.
Rocky for a period from 1 year from 1 year prior to the incident to the present day. If Relly made statements on social media regarding regarding Rocky, that's fair game. Voicemail, fair game. Oral statements made to any person, to anyone, is fair game, as long as if there's a denial, the recipient must be available. If Relly says he didn't make the statement. Any written statements by Relly to anyone is fair game. The recipient, however, must be available if Relly denies that he made that written statement. Recorded or oral telephone conversations in which Relly is a party is not permitted under under Penal Code Section 632, unless all parties to the conversation consent to the recording.
Dang, he's letting it all
Those
in.
are the parameters, and that's in stone.
Your Honor, we have just questions, not questions, we have specific questions of what they.
Joe is over there.
I just set forth the parameters. If you think that something contravenes what I just said, lodge an objection. Okay, I'm not going to do any clarifying because it would take us forever for both sides to go through question after question. I set parameters. Both of you know. If you think that on either side, if a question contravenes these parameters, lodge an objection. All right, different topic.
Cooked.
Does the prop gun exist?
Your Honor, do you want the witness to go out of the now?
What witness? Yes, because we're going to be talking about evidence. Yeah, yes, please step out.
Your Honor, while he's here, the court wanted to inquire of him on the issue of whether he's willing to speak to the defense.
So they're gonna let it in.
Mr. Relly, the defense, I know you've been interviewed in the past and you've been examined in court a number of times.
Oh, Relly is
The
here.
defense would like to, I guess, question you further, get an update on any information. It's your decision whether you want to or not. It's optional. You can say, yes, I'm willing to be interviewed, and if you are, that's fine. If you don't want to be interviewed, then you don't have to. It's your decision. But they want to know whether you're willing to sit for an interview. So what's your response?
I respectfully decline.
Okay.
Of course he
All right, you
does,
step out,
bum.
and, we'll have you come back in when we're ready for you.
Yeah, get him out of there.
Either of the defense witnesses are in court right now.
Okay. Well, I'm going to.
So just before we were gonna, either the court can,
We're going to deal with that.
no, the court was starting to talk about evidence in the case, and I wanted to make sure that they were not in here while the court was going to talk about the
Oh,
problem.
yeah. So Mr. Levin and Mr. Phillips, they are not the court. All right. All right. Does the prop gun exist?
Prop gun existed, yes.
Does it exist now?
I don't know if it exists now. Are you asking, do we have, are we going to produce it?
Yes.
No.
They're not producing the prop gun.
All
What?
right, let's deal with Mr. Levin. Is he outside?
Yes.
All right. Can you have him come in?
This is interesting, guys. This is interesting. They said the prop gun, they're not going to produce it. Joe did not say it doesn't exist. They also said that ASAP Rocky doesn't have a 9mm, which is another issue because that gun, or the alleged gun, is gone. Wild. Do y'all think that was a smart move? I'll ask you in a poll.
Really can't. Now, you?
I mean, I think technically, obviously, we're going to be asking questions that go to this area. Council, I don't have a problem with being here. Council has an objection. I think
Crazy.
Do you see any reason why you can't be in here? I'm going to be talking now about Levin and Phillips, so I'm not talking anymore.
I don't think he should be in here.
If you don't think he should be in here, then he's,
And I don't think Levin should be in here after you've done with me.
he doesn't need to be. I just, are you Mr. Levin?
I am.
What's your first name, Mr. Levin?
Lewis, L-O-U-I-S.
Wow.
Deputy Bennett, could you give him a piece of paper? On the piece of paper, I want you to write your birthday down.
Yes.
I don't want you to stay in an open court because this is being recorded and, you know,
Understood.
the public doesn't need to know what your birthday is.
Thank you.
Oh, look at this judge
Once you
protecting the
write down your
people.
birthday
Shout
on a
out to
piece of
him.
Paper, give it to Deputy Bennett. Deputy Bennett, give it to the prosecutors and they can.
Respect, Judge. Respect. All right, come on now, Law and Crime. Let's do this. There we go.
Have you done that?
There we go. All right, y'all give me 1 second. Oh man, hopefully there's not an issue with the stream. Y'all bear with me a second. There we go.
All right. I want you to know, though, if you refuse, then the jury is going to know that you refuse to be interviewed. Exist.
Clock gun.
So the stream's working on your side? Okay.
Does
It
exist
must be me
now?
then. It must be me. Hold on.
I don't know if it exists now. Are you asking, do we have, or are we going to produce it?
Yes.
No.
All right. Well, that answers that question. All right. Let's.
I think
deal
it's me.
with,
We should be
Mr.
good.
Levin. Is he outside?
Yes.
All right. Can you have him come in? And I don't see any reason why really can't. Now, you?
I mean, I think technically, obviously, we're going to be asking questions that go to this area. Council, I don't have a problem with being here. Council has an objection. I think we'd be
Do you see any reason why you can't be in here? I'm going to be talking now about Levin and Phillips, so I'm not talking anymore.
I don't think he should be in here.
If you don't think he should be in here, then he's,
And I don't think Levin should be in here after you've done with me.
he doesn't need to be. I just, are you Mr. Levin?
I am.
What's your first name, Mr. Levin?
Lewis, L-O-U-I-S.
Deputy Bennett, could you give him a piece of paper? On the piece of paper, I want you to write your birthday down.
Yes.
I don't want you to stay in an open court because this is being recorded and, you know,
Understood.
the public doesn't need to know what your birthday is.
Thank you.
Once you write down your birthday on the piece of paper, give it to Deputy Bennett. Deputy
Here we
Bennett,
go.
give it to the prosecutors and they can investigator.
No, Relly's he's gonna be there.
Have you done that?
I have.
All right, Mr. Levin, the prosecutors, they want the opportunity to interview you before you take the stand. It's optional. You can agree to do it, or you can refuse to do it. It's just totally up to you. Were you advised of this?
No.
All right. These are the prosecutors, and they just want to explore what you have to offer in this case. Are you willing to be interviewed by them?
No.
All right. Step up
Your
here.
Honor, can witness be advised that the failure to...
Oh, yeah. I just want you to know, and Relly will be told the same thing. By refusing, this can be brought out on cross-examination that you refused to be interviewed by the prosecution, which could impact your credibility. But that's totally your
They don't
decision.
care.
If you don't want to talk to the prosecutors, you don't have to. If you agree to, you can. But I just want you to know of the consequences.
I understand that.
You still don't want to speak with them?
Correct.
All right.
I'm assuming he can give an answer as to why he doesn't want to. Correct.
Yeah, well, if he's asked?
Yeah.
Yes.
Okay.
Of course. If he's asked, if he's confronted with, isn't it true that we wanted to speak to you and you refused, he'll say yes. And then the prosecution asks, or you can ask, why did you refuse? Sure. If it's touched on direct, it can be touched on, if it's touched on cross-examination, you can touch on it on redirect. All right, step out, please. And what about Phillips?
Your Honor, before we go on to Mr. Phillips, we still do not have, counsel has never provided the date of the interview with him.
That's ASAP Rocky's manager, by the way.
How many there were?
Or the tour manager.
I have things in a certain order. What about Phillips? Where is Phillips?
He's in New
He's
York.
in New York?
He's in New York. But we contacted him and alerted him to the fact.
Okay,
that
call him. Can you call him?
Sure. Doing that, Your Honor.
Did you get the birth date on Mr. Levin?
Yes.
Okay. What is Phillips' first name?
Jamel. Jamel? Yes.
Jamel.
Can you put are you able to put on speakerphone?
Yeah. Yes. All right, Your Honor, Mr. Phillips is here on speakerphone.
All right. Mr. Jamel Phillips?
Hello, how you doing?
All right. Captain, can you hear me? All right, Mr. Phillips, I'm the judge in the case. You're aware of the case, yes?
Yes, sir.
All right. Two things I want to inquire of you. At some point, you're going to be coming to court to testify. You're aware of that?
Yes, sir.
All right. The prosecution would like the opportunity to interview you before you take the stand, just to find out what you have to offer and what you have to say.
He said.
It's optional with you. You can either agree to be interviewed, or you can refuse. Are you aware of this? Are you aware of this?
Yes, sir.
All right.
ASAP Rocky's out on $550,000 bail.
No, I do not want to be interviewed.
All right. I want you to know, though, if you refuse, then the jury is going to know that you refuse to be interviewed by the prosecution, and it could impact your believability or credibility in the eyes of the jury. Do you understand that?
Yes.
All right. What I'm going to do now is I'm going to have you taken off speakerphone, and the phone is going to be given to the bailiff. Mr. Phillips, I want you to give your birth date to the bailiff. No one is going to be able to hear it except her. She's going to write down your birth date, and she's going to give it to the prosecution, because the prosecution is entitled to at least look into your background, and part of that is required that you give your birth date. But It is not going to be broadcasted or publicized in any way.
Your Honor, the court also inquires whether or not he has a residence outside of New York, or has had a residence outside of New York.
Do you live here in California?
No.
Do you have a residence here in California?
No, not in my name. No.
Not what?
No.
Do you have a residence anywhere beside New York?
No.
All right, so when you were out here, were you just visiting?
Yes.
Okay. All right, go ahead and take it off speakerphone. All right, and Deputy Bennett, let him know when he's off speakerphone, and then have him give you the birthday. Do you want him on like 24-hour call or is that handled? Say again?
We'll handle it.
Yeah, can't be giving out people's
All right,
birthdays. Ooh.
All right, getting back to Mr. Levin, since he's being called as a witness, how many times has he been interviewed by anybody from your office?
Twice, Your Honor.
Okay, when was the first time?
It would have been mid-August, Your Honor.
Of 24?
24.
And where did the interview take place?
In our office in Manhattan.
Was the interview recorded in any way?
It was not.
Who was present for the interview?
Mrs. Takina and Ms. Lanzoni, along with myself.
How long did the interview last?
I'm trying to recall, Your Honor. About an hour.
Oh no, y'all said.
Hour and a half. And nobody took notes or prepared a written statement as to what Mr. Levin said?
No, Your Honor, it was a conversation.
I had said that the people are entitled to at least know the sum and substance. Since there's no written recording of what happened, the people are entitled to
Talk to
know
him,
the sum and
Judge.
substance of your conversation. So that is to be generated today.
We did that, Your Honor. We provided it.
Oh, you did?
Yeah, the court trial. If the court recalls, Your Honor, the court made an order that they were supposed to turn over the discovery.
Did they?
What we originally got was, we got a paragraph saying he was going to talk about his observations, not what the observations were. The day before we started trial on the 20th, we got approximately a 15-line summary that certainly would not take an hour and a half. No dates as to when the interview occurred. Nothing about who was there. By the way, even now, what they're just told the court is, there's an interview in mid-August. They can't even say what date it was. And what they gave us was simply, apparently, a combination
What's
of
the date?
everything he said.
I know you know what date it is, so what's the date?
It would have been August 16th or 17th, Your Honor.
All right. When was the second time you interviewed him?
Okay, thank y'all for letting me
No,
know.
not about. When was the second time?
Or of course, I'd like to have questions to go with too, right? On this. I mean, we have the same issues with some of the other witnesses, right?
All right. Well, let's deal with this, and then I'll listen to what you have to say. All right. When was the second time?
It was the 26th, Your Honor.
So 10 days later?
No.
No, 2 days ago, January 26th.
Oh. Where did that interview take place?
That was at our hotel.
How long did that interview take?
Yeah, about the same amount of time, Your Honor, an hour and a half.
So, was that interview recorded in any way?
No.
This one's not me. This one's the Law and Crime feed. Y'all bear with them for a second. You can see because everything's still strolling. So they're working on the feed. And it looks like so far, I asked y'all in the chat, should the defense produce the prop gun? Most of you say yes.
The court's aware, on the 20th, the court expressed skepticism, on the 15th, the court expressed skepticism that the defense did not record it, did not write anything down, did not have any substance as to what was said.
Right.
So apparently, after the court gave that lecture, they conduct another interview 2 days ago, where again, they don't record it, they don't make any notes about it, and they don't turn anything over.
They're not required to. If they choose to do their job that way, then they do their job that way.
They are required to let us know.
Is
that
it
they
well?
interviewed the defendant, or the witness.
Yeah.
They have to let us know if that interview took place, when it took place, who was there. It appears, and again, I'm not going to pull punches. It's very clear.
Boy, they're scrambling,
What do you
man.
suggest?
Well, what I suggest is I find it completely disingenuous that we have 3 hours now worth of interviews. We got a total of about 15 lines. Very little detail about what's going on. And so if all of a sudden he ends up testifying to more detail than he gave, and the court already has because we've sent it, if he ends up testifying to more detail than what he has previously provided in this miniaturized summary, then we've got a discovery violation.
Who's going to be a question? Is that you? All right. Are you going to be going into any subjects or areas that are not covered in what you gave to the prosecution?
Nope.
So
Why would he do that?
There is nothing that you are going to ask about that does not fall within the summary. That's correct. Correct. Okay. Then I think there's been I think discovery's been satisfied.
Well, at least this point,
Right.
we can't demonstrate the discovery's not been satisfied because he has.
This is tough, man.
Does the court really believe that
Prosecution
he has
is
3 hours of interviews,
struggling.
lines? I don't.
I have. This is not the first time I've been aware that lawyers
Many
don't
left.
take notes of interviews. If Mr. Siegel represents to me that no notes were taken, or Mr. Tacopina represents to me that no notes were taken, I have no basis to disbelieve it. Would I do it that way? No. But if they choose to do it that way, that's their choice. He told you, Mr. Siegel just told you, that any topic that's going to be inquired about is in the summary that you've got. So for now, discovery has been complied with. All right, let's talk about Phillips. When was the first time Phillips was interviewed?
That's what
Oh, is that 1 week?
We were just talking about Levin.
no,
Levin. We were just talking about Levin. Right? We're not talking about Phillips. All right. When was the first time Mr. Phillips was interviewed?
It was a week after we interviewed Ms. Leonard.
All right, around August 23rd?
That's right.
And where did that happen?
In the office.
Okay, and who was present for that?
Same circumstances, Mr. Tacopina, Ms. Lanzoni, and myself.
And how long did that interview take?
Yeah, about an hour, Your Honor.
1 hour? No notes? Or no report?
No.
Nope.
Did you provide a detailed
Look at
outline
Rice Street.
of the sum and substance?
We did. At the same time, we provided that detailed substance.
Now, do you intend to go into any areas with Mr. Phillips that
Shout
are
out to
not
Rice Street.
within the summary that you provided to the prosecution?
No, Your Honor.
Okay, how many other times did you interview?
That was there.
That's the only time?
That's right.
just so it's clear, Your Honor, we were provided literally with about 12 lines of Mr. Levin's alleged testimony. The issue is not...
We're talking about Phillips now.
Excuse me. Levin was 12 lines. Phillips was 18 lines.
Okay.
And I should just add that the issue is not that they're not going to cover a new area. It's that, as an example, when Mr. Phillips is talking about the actual incident, there's very little information there. It would appear, as the court is aware, the first thing that they said in discovery was that the witness would testify, quote, about his observations during the incident. So they then follow that up with, well, okay, we're now going to tell you apparently a little bit about what he's going to say. So again, Your Honor, this is our concern. Because we've provided with so little of what actually happened, it's not that we're going to introduce a new topic. It's that all of a sudden, these witnesses are going to get on the stand, and the amount of detail they are going to give is going to be completely inconsistent with the minimal information that we were given. When you add in the fact, and again, they're not required to take notes, but they are absolutely required to immediately after provide, if they're not going to take notes or record, an accurate summary and statements of what the witnesses said. So our concern is we basically were given nothing, almost zero. They're going to get up on the stand after, again, 2 hours for one, an hour for one, 3 hours prior to the other, and they're going to testify in greater detail. That, when you combine that with the prior attempts and not turning over discovery, even after the court's order,
ASAP Ricey.
the inescapable conclusion that they're not complying with the meaning of the letter in the court's order. So I understand the court doesn't have anything it can do now, but the court has been furnished with the discovery they provided. It's not a long read, as I said.
I haven't been provided any.
It's in, I believe it's in the emails that we have sent. If not, I will give the court a copy, but it's literally on one page for both of them.
If I'm understanding you, Mr. Siegel, that any topic that you're going to cover on direct examination,
I'll be doing this, Mr. Phillips.
All right. Am I correct in assuming that any question that is asked on direct examination by either counsel or Mr. Levin and Mr. Phillips is encompassed in the summary that's been given to the prosecution?
Yes, Your Honor.
All right. I just wanted to yes or no. All right.
I'd like to say more than one word.
Wait. All right. I don't see any other topics to go into. All right.
In terms of on this issue of the total.
For now,
there's a couple of other issues that people have. The first issue relates to, it's not just the real evidence of profit. We've been furnished with only 2 witnesses that they're calling.
Right.
It is our understanding there will be no other witnesses that will be called to testify about profit.
Y'all come on so we can get Relly on the stand, man.
Counsel and I have been asking for days, in email the court is talking to you, are you planning on producing the gun in this case?
he said no.
Well, they refused to answer that question the last week we've been asking.
Now we're crying about the gun.
Are they now planning, which would be against the court's discovery order, to call any other witness regarding the profit information? Can the court please inquire? We've only been told there's 2 witnesses they're calling. Plus, maybe.
Oh, that's why. I see.
So, any other witnesses that you intend to call or reasonably intend to call?
But the only possibility is sitting right to my right, Your Honor, right?
All right, so it's either the 11th.
Ooh, so Rocky might take the stand?
The next issue that we would have, Your Honor,
That would be crazy.
we want to make sure. There have been times where counsel has asked to approach, but he still wanted to be on the record. Our position going forward is that unless it is something having to do with an issue with the jury, the prior times occurred before the jury was selected. Counsel made certain arguments in open court, then he asked to approach, and he made different arguments, but he wanted to do it on the record. Unless the court orders it, and there's a good reason, the last time this happened, Your Honor, as the court is aware, counsel elected at his request to give a speech that he was very happy with this jury, wanted it to be known that he was happy with the jury.
Give a speech to who?
You are.
Stop, don't interrupt.
Okay, fine.
You'll have a chance.
No, I know, but he should.
You'll have a chance.
I know
Wait
what
till
he's
he
doing.
finishes, then you will have a
I
chance.
know what he's doing right now.
Do not interrupt either of neither of you interrupt
There you
the
go.
other.
I hope Rocky testifies.
He said, I need to say something in open court. And then he made a statement about how they were very happy with the jury. Clearly, it didn't matter to the court. He then asked to approach. When we asked to approach, he said he wanted to do it on the record. On the record. But outside the press, he then complains about jury selection, about a specific juror, etc. We are not going to participate in Mr. Tacopina's attempts to manipulate the media. Again, that ties into the fact that when the case started, I very kindly said to Mr. Tacopina, hey, listen, I know you've been speaking to the media before trial. There was no worry of every trial.
Shout out to Megan Kunev.
Are you going to be saying anything once the trial started? He assured me in front of my co-counsel, the response was, John, I would never do that. I won't be saying anything to the press. Meantime, he is speaking, I already sent the court this, he's speaking to TMZ, he likes to say things to the press as he leaves the building. We took him at his word that he wasn't going to be talking to the press while the pendency of this trial was going on. This is necessity as an example. We ended up hearing his arguments basically about the jury issues repeated by Al Sharpton. We're not going to try this case in the press. We're going to ask the court at this point to order Mr. Tacopina to not speak to the press during the pendency of this trial.
Okay, I guess I'll start in reverse. First of all, I'd like him to provide a quote of what I said to the press, because one thing I've never done is speak about the facts of this case since the jury's been out. Never. Okay? But I do have here a quote from the district attorney, Mr. Hoffman, who did quote to Extra that he appreciates any time defense counsel is pretty sure they're going to prevail, but we don't bring cases unless we're very sure we can win those cases by establishing and meeting our burden of proof beyond a reasonable doubt. I believe that when we see the evidence that's going to be presented in this case, we'll meet that burden. So that's their district attorney. Okay? So I should be able to rebut something like that. That's different. That's saying we're going to win the case, we know the evidence, and we'll meet our burden. I talked about nothing other than the potential issues with the jury. I didn't speak about the facts. I didn't speak about Mr. Efron. And I won't do that. Now, the last thing he said was I spoke to TMZ. Again, I defy him to provide to the court what I spoke about, because I didn't violate any order. First of all, there's no order. But I certainly, I know enough not to speak about the facts of the case. By the way, I did an opening statement to the jury. Certainly, I would never say anything outside of that opening statement, but I didn't even do that, Your Honor. I simply talked about the issue with the jury. And the reason I did that is because he just did again what he did the other day. Stood up and said, we're not happy with this jury. Try and get that message back to the jury that we're not happy with them. That is not the case. But, Your Honor, the reason I raised the issue about maybe we would have selected a different jury, or certainly a different juror or two, is because of the late disclosure of the ballistics report after the jury was impounded. And we have a right to make that record. It doesn't mean I'm unhappy with the jury. So, speaking of disingenuous, we're going to now get into disingenuous. But I did nothing but protect the record, protect my client. So that's first and foremost. So again, the issue that I spoke about off record was caused by their late disclosure of a report that was generated over a year ago by their lead detective in this case. That Mr. Lewin wants everyone to believe he just stumbled upon 3 days ago. He just stumbled upon 3 days ago.
You don't have to whisper, just talk.
Try to get that middle ground there.
Just talk in a normal tone of voice.
Nah, be you, Joe. Come on. Shut it down.
He made all these accusations about that's disingenuous. I don't believe it. Well, I don't believe that they just found that report from their lead detective who they interacted on a daily basis in this case 3 days ago. I don't believe it. That was done in January 2020.
I already made findings.
I understand.
In my view, nothing nefarious. I don't want to go over things that we've already gone over.
Well, we just did. We still haven't done it.
He's asking that that both sides be directed not to make comments to the press. That's what he's asking for now. I'm not poking fingers. I'm not accusing anybody of any unethical conduct. Let's just move forward. Here's what I want to have.
I have more things.
Oh, go ahead.
All right, I just listened to it.
Go.
Now, we heard a little about the discovery.
They don't need to
issue
talk
about,
to.
This not being enough. I think this is incredibly detailed when it comes to Mr. Phillips, especially if this is a videotape. This is really detailed. Tell what he's going to observe at the scene, what he's going to testify to, what he observed at the scene. Putting that aside.
Based on what I've heard, I am satisfied under the circumstances that both sides have satisfied this discovery rules. So there's no reason to go over about whether you have complied with discovery. I already found that you did.
Okay.
ASAP grabbing.
There was a police officer, the first one out of the box, Sergeant Zizza.
Right.
The only thing we have from them, because, you know, I assume the rules apply to both sides, right? The only thing we have from them is a few-line email saying we spoke to him on Wednesday. He testified Friday, recall. We spoke to him on Wednesday, and Jack, you have the email?
Yeah, we want Relly, man.
Here's what we have from them on Officer Zizzo. That they spoke to him on Wednesday, which the officer denied on the witness stand, by the way. He said the first time he spoke to him on substance was the day of his testimony. He said that he advised the district attorney that he responded to the shooting while on patrol, and it's common occurrence that the receiver called a shooting and respond only either to find no evidence or the victim, but also sometimes find out whoever called was intentionally misrepresenting. 2 sentences. That's the discovery. He testified that 1, he may have missed the bullet casings, and 2, he didn't know where to look. 2 sort of important things and he didn't agree, he didn't search the entire street. That was not in their disclosure. Not their disclosure at all. But yet I'm being accused of not giving them the right information. First of all, I don't have the date. There's nothing in that disclosure that they interviewed him Friday before his testimony. We don't even have that interview. We don't have that date. We have Wednesday only. The witness said, no, I didn't speak to him on Wednesday or something. That was just about logistics. Okay, so before we start casting aspersions, I was going to even raise it, Mark. Just happened. I understand this is trial. But, you know, being that we're now throwing stones, let's call the kettle black.
Let's not throw stones.
Well, I know, but they started. So I'm going to respond.
This is a no squabbling zone.
Oh, after he swallows. I'll swallow back.
Well, you're a good squabbler. You're doing a good job squabbling. All right.
He said you're doing a good job squabbling.
Regarding what Sergeant Zizzo testified, did he write a report?
He did not write a report, Your Honor. But he...
You think that's a Fenty suit? Ugh.
That's been provided.
That was provided.
All right.
Years ago.
You're an experienced attorney. All of you are experienced attorneys. Sometimes, you know, a witness will say something that is not in a report. That's to be expected. A report is a summary, a sum and substance of what the witness said. It's much more fleshed out when the witness is on the stand.
Well, I agree with that. I'm okay with that. I'm not even going to make the big. I'm not even going to raise the fact that he said he didn't speak to him on Wednesday and he only spoke to him. I don't do that. It's petty to me.
It is petty.
But I want to make sure that what's good for the goose is good for the gander. That when Mr. Phillips testifies and he says something, a word that's not in this thing, it's not like, you didn't tell that to the lawyers. It's just not right. No one. This is not a transcribed statement. There will be nothing outside the scope of this. But the same way I didn't get anything from them regarding, I may have missed the shell casings. I didn't get a report that said that or a statement.
Again, to be repetitious, I do not find either side has violated any discovery statute or any discovery rule. Regarding the press, the jury has been told not to read or watch anything about this case. I'm going to assume that they follow that rule. But what I am concerned about is someone that the jury knows is going to read or watch something about the case and then relate it to the jury. So, here's the rule. I don't want any attorney in this case saying anything to the press while the case is going on. That's it. So you can call it a gag order.
We will advise, obviously, courts where we've said nothing. We will advise the DA.
Oh, the jury's always watching.
The DA responded to Mr. Tapapina's published report where he dared, quote, Nathan Hockman to try the case himself. But we're going to tell the DA.
Let's move forward. Yeah, just let everybody know in your office who may say something. Tell them not to say anything to the media or the press.
Will do, Your Honor. We had 2 last issues which are brief. The first issue is we're going to request, we made this request before, Counsel and I've tried many cases in front of the court. If there's anything even close, I 402 in advance. If there's any evidentiary issue, which is even a close call, in terms of the defense introducing, bringing up, asking questions, we want to make sure that they have to approach and that be 402. You don't want to be in a position to have to unring the bell.
That goes for both sides.
Finally, Your Honor, the court is aware. On Friday, it doesn't really matter what the circumstances were. Mr. Tacopina literally started screaming at me in the. So again, Your Honor, I have not interrupted Mr. Tacopina.
Nah, Rihanna's appearance won't help at all.
Makes noises. Again, if there's got to be a certain decorum, we're following it. But you know, you can't bring a knife to a gunfight. So we would appreciate, as the court is respectfully instructed, and when one lawyer is talking, the other lawyer not interrupt. Mr. Tacopina, as court is aware, started literally screaming at me in the courtroom. He basically appeared to challenge me to a fight.
Oh my gosh, are you serious?
Again,
Look at Rocky, he said.
I've not had that experience occur.
Bro.
I am not going to be treated that way by anybody.
These guys crying.
In a court where I practiced for more than 30 years, in front of a judge I deeply respect. He doesn't have to like me, he doesn't have to get along with me, but he cannot be screaming at me, whether on or off the record. The court was here.
This is crazy.
I mean, everyone heard and saw it. It's not right.
Yo, California, y'all gotta do better, man. This is a grown ass man talking about getting yelled at. Sheesh.
So I'm just asking.
ASAP Crybaby for real. Shout out to ASAP Crybaby.
And you are, both of you are
It's embarrassing.
attorneys, aggressive attorneys, both of you are.
We are due to zealous aggressiveness. The court has not heard me yell or scream at anybody. And again, I just.
Such a waste. Where's the 403? Can y'all type 403 in the chat? This is insane.
Why don't we do this? I did not hear you yell. I did not hear it. If it did happen, it wasn't in my presence. Because you two have this relationship, why don't you not talk to each other unless it's on the record?
Oh, that's.
And then I am involved.
That train is silly. Yes, absolutely, I agree with that. But I want to respond now, because, you know, I can't have it always one way. He makes a record, disparaging remarks, and then I gotta sit.
This is really happening right now.
You were right there, Your Honor. What's happened, and Mr. Siegel was with me, is Mr. Lewin comes up with his little scolding, sort of bullying attitude, telling me we don't know the rules here, and we're not doing this right, and he didn't like the opening statement, and so on and so forth. So I responded. I don't need a lecture from him. Okay, I'm not going to go into the amount of phone calls I got regarding him.
This is wild.
Before this trial started, from lawyers I don't even know, including lawyers inside the district attorney's office currently. Okay, I'm not going to go into it, Your Honor. I'm not petty.
No, and now you're interrupting him. Just that you were complaining about him interrupting you. You're interrupting him. Don't.
I'm not.
Grown ass man. Oh, this is crazy. I cannot believe this is happening. All right, guys. Now, Jimmy, play nice with Tommy. Tommy, now don't interrupt your brother when he's talking. Insane.
I'm going into it, Your Honor. I just don't want to do that. But please, there was no one yelling. You were right here. There was an argument between both sides, both of us. I agree. And that's not going to happen because I'm not going to speak to get off the record. So you're right about that. That's number one. Number two. You know, there I have to also raise an issue, and I'm not past that. I don't want to even talk about that. Your Honor's here. That's the end of that. Mr. Lewin did something last week that was inappropriate. The reason I'm raising it is because I don't want it to happen again.
Uh-oh.
This week, Mr. Mayor's significant other may appear here. Last week, Mr. Lewin, as is his playbook apparently, one of the lawyers, went up to my client's family and told my client's family that's not personal, but you know they should really Hopefully he's really thought about taking a plea because she was facing a lot of jail time and saying things
Oh, no.
that played on the emotions of the family.
That's
He should have
terrible.
no communication with the defendant's family. I've heard he's done that in every case. That's right here. Well, I don't want him, and I want the court to instruct him not to communicate with anyone on this side of the fence. Not the client's family, not the client's relatives, not the client's friends. Because it's inappropriate.
So, Your Honor, so what happened was, is I walked up very kindly to the defendant's mother and sister, and I said the following.
Look at Rocky.
I'm very sorry that you're having to go through this. I have kids myself. I have siblings myself. I know this must be difficult. It's not personal. And I'm truly sorry for what you are having to endure.
All right.
And then I said as follows. I hope that your brother and your son, I hope that he's really evaluated what he is risking here, because he is a lot.
All right, there's nothing that prohibits.
Wow. Hold this guy in contempt. What in the world? He walked up to his family and said that, hey, Rocky's doing better than me. He's sitting over there holding it together. Insane.
At the time,
I've heard enough. I've heard enough. There's nothing that prohibits what Mr. Lewin did. You've heard now that the defense does not want you to approach anyone from that side, so don't approach anyone from that side.
It's intimidation. That's nasty, nasty work.
There's just one evidentiary issue we need to deal with.
Another one?
Yeah, unfortunately,
What is it?
Mr. Lewin bring up
What is it?
402 every moment. I just want the record clear on this.
What is it?
It's that the defense doesn't need to preview our impeachment material on an eliminate motion. Mr. Lewin keeps saying we need to bring it to the court's attention or his attention when we plan on introducing or using evidence so that he can have a 402 hearing. The law is crystal clear. If I don't need to go further, I won't.
I've not seen Rocky's mom.
But the law is crystal clear that there's no rule of law that would require the defense to disclose evidence gathered by an investigator who may tentatively be called by the defense for impeachment purposes. That's Hubbard versus Superior Court. I'll continue. People versus Hunter. Section 105, 4.3, subdivision A1 provides that the quote, defendant and his or her attorney shall disclose to the prosecuting attorney his or her intended witnesses together with any relevant written or recorded statements of those persons or reports of the statements of those persons, which we complied with. But the court goes on, but that does not include impeachment statements.
All right, go ahead.
But that does not include impeachment statements a defendant obtains from prosecution witnesses. The prosecutor is not entitled to statements impeaching prosecution witnesses. That's People versus Hunter. People versus Sloan. Here, the defense, the court noted, could use the messages on the tape to impeach a witness without disclosing the tape to the prosecution. The prosecutor was wrong that using the tape for impeachment was the same as introducing it into evidence. A few more cases. People versus Ledesma. The court noted to the extent the evidence at issue was admitted to impeach, counsel may have been unwilling to give the prosecution the benefit of a preview of the defense case in order to obtain such rulings, which is what apparently Mr. Lewin is seeking to do now, but the court noted that the defense was appropriate in the way it proceeded. Two more. Izaga versus Superior Court.
This is Izaga, yes.
Right. The defense is not required to disclose any statements it obtains from prosecution witnesses it may use to refute the prosecution's case during cross-examination.
And you're going to mention Tillis.
I'm going to mention Morrison, in which the court noted, nor did the discovery statutes obligate counsel to disclose she would impeach a witness with evidence of prior misconduct, particularly in that case, gun possession. Now, I understand, Your Honor, that the prosecution here wants us to do their homework for them, but the law doesn't require us to. For that matter, all of the impeachment material that we have arises from their own discovery.
All right, let me tell you my view on impeachment. I'm aware of Izaga, but that's a California Supreme Court case. There's another California Supreme Court case that's called People versus Tillis, T-I-L-L-I-S. Both of them say the same thing. Impeachment evidence does not have to be disclosed. Impeachment witnesses, once the decision has been made to call them, does have to be disclosed. But the evidence does not.
Very good.
All right, we are at 5 minutes to go. I I don't want the jury to wait. So let's give Kathy a break, and if anybody wants to use the facilities, they can.
Here we go.
I want to get started right at 10:30.
Don't leave before we wait for a second, just logistics.
What's logistics?
Not controversial. The piece of evidence we put in on the defense exhibit.
All right, so let's skip ahead because we're on a little bit of a delay. Let me see if they're back yet. Oh, we weren't far enough behind. Dang, delay game. We lacking today. Shout out to everybody who's in here too. We're gonna wait until they come back. How many of y'all we got in here? Over 800 of y'all still in the building. Shout out to the gang. And big shout out to my dog Rice Street, by the way, gifting 20 memberships. Rice Street going crazy in here, man. Thank you, Rice Street, for gifting those memberships. If you got one of those 20 memberships from Rice Street, please make sure you say thank you. He shows up every single show, showing love and support. Thank you, my guy, and one of the amazing moderators over here as well. So y'all make sure you say thank you to Rice Street. What is up with these prosecutors, man? I can't believe they had a back and forth about them yelling at each other. I have not heard Joe yell at the prosecutors, and we watched preliminary hearings. We watched his opening statement when he was being interrupted and they were objecting every 5 minutes, it seemed like. Joe kept his cool. Just let them roll off his back and he kept going. Now, it's just surprising to see that they're fighting this hard or being yelled at. And then you've got all these witnesses coming in that don't want to be interviewed by the prosecution. I mean, I don't think anybody's surprised either. Yeah, Joe, he's in there doing his thing. Let me see what Law and Crime's got going on. Let me refresh and see. What do y'all think though? And I asked y'all another poll in the chat too. Should ASAP Rocky testify? Most of you are saying no. Interesting. 60% of you said no. 39% of you said yes. I'm going to agree with the 61% of you that said no. I mean, unless things somehow go left, I don't see really looking good in this in any way, or his testimony being believable. So I'm with y'all on this. I don't see a reason for ASAP Rocky to testify. I mean, they've already got all the evidence they need. They can show the video. You really don't even see him pointing the gun at anybody. And even in the one video where Joe says, yeah, that's Rocky right there. If he fired the gun, they're alleging it's a prop gun. Also, ASAP Rocky, we can see from the video, he initiated the contact. So it's wild, man. Leslie said, here we go. Joe is telling on them it's a bad idea for him to testify. Yeah, I don't think he needs to. I mean, unless he doubles down on the self-defense aspect. Yeah, I kept this thing on me because things were getting complicated. I mean, he's basically just going to reiterate what Joe says. But if he doesn't have to get on the stand, I wouldn't. Sarah says, maybe he does, maybe he will. Relly's going to kick Rocky's ass. Maybe. Yeah, that's possible. But that's also the guy that was holding up the shell cases, sending them pictures saying, I'm going to get rich. I'm going to sue y'all. It's wild, man. It's a bad idea to testify. Here we go. Joe's telling on him. If I was Rocky, I'm like, I'm not paying for this part. Nah. Who keeps complaining on the state? Yeah, I need to figure out. Let me do some research and find out who this other prosecutor is, because I got the name of the first guy. Let me see if I could figure out who that is. So we've got the first one was, I think we got John Lewin and Paul it's P-R-Z-E-L. I have never seen that many consonants together. P-R-Z-E-L-O-M-I-E-C. Jeez. And then we've got John Lewin, of course. And he's the one that is the ASAP crybaby, as we're calling it. And then the other guy that is going to be Paul Frizelmalik? How do you pronounce that? Somebody help me in the chat. Valencia said, what did he say to the family? So apparently John Lewin, and maybe we can rewind it. He walked up to the family and said, hey, I'm so sorry for everything that's going on. I can't imagine going through this. I have kids. My kids were involved in this situation. It would be just devastating. And I don't want y'all to take it personally. I'm just here doing my job. All right. Also, that boy better take a plea, because I'm about to cook him. So anyway, have a nice day. That's essentially what happened. And you saw, I don't know, you probably missed it. You saw ASAP Rocky's reaction. He was not happy about that. And obviously he found out from his family. Yeah, I don't know who he said that to. I think it's alleged that he said that to Rihanna. Wild, man. And shout out to Sarah, is reminding y'all to like the video. Shout out to everybody who's in here too. It looks like we still got a bunch of y'all in here. Over 900 of you have liked the video. Thank y'all so much for liking the video. So they're going to take a brief break. Let me do this while we're on break. Yeah, that's Deputy District Attorney John Lewin, which allegedly he has a good reputation. I want to see how to pronounce this last guy's name, though. Let's see. So we've got, it's a Polish name and it's pronounced Pushlomites. What? Pushlomites. Pushlomites? Pushlomites. Yeah, I don't know, y'all. I tried. Anyway. Rihanna should be in court promoting Fenty. That was an intimidation tactic. Now he's looking foolish in court because ASAP's attorney is cooking him. Their prosecution is a joke. I agree. Y'all want to go back and see where he's like, well, Judge, I was just talking to them.
Go. Now we've heard a little about the.
Let's see if I can find it.
First of all, I'd like him to provide a quote of what I said to the press, because one thing I've never done is speak about the facts of this case since the jury's been out. Never. Okay? But I do have here a quote from the district attorney, Mr. Hoffman, who did quote to Extra that he appreciates any time defense counsel is pretty sure they're going to prevail, but we don't bring cases unless we're very sure we can win those cases by establishing and meeting our burden of proof beyond a reasonable doubt. I believe that when we see the evidence that's going to be presented in this case, we'll meet that burden. So that's their district attorney. Okay? So I should be able to rebut something like that. That's different. That's saying we're going to win the case, we know the evidence, and we'll meet our burden. I talked about nothing other than potential issues with the jury. I didn't speak about the facts. I didn't speak about Mr. Efron.
Shout out to Sarah.
And I won't do that. Now, the last thing he said was I spoke to TMZ. Again, I defy him to provide to the court what I spoke about, because I didn't violate any order. First of all, there's no order. But I certainly, I know enough not to speak about the facts of the case. By the way, I did an opening statement to the jury. Certainly, I would never say anything outside of that opening statement, but I didn't even do that, Your Honor. I simply talked about the issue with the jury. And the reason I did that is because he just did again what he did the other day. Stood up and said, we're not happy with this jury. try and get that message back to the jury that we're not happy with them. That is not the case. But, Your Honor, the reason I raised the issue about maybe we would have selected a different jury, or certainly a different juror or two, is because of the late disclosure of the ballistics report after the jury was impounded. And we have a right to make that record. It doesn't mean I'm unhappy with the jury. So, speaking of disingenuous, we're going to now get into disingenuous. But I did nothing but protect the record, protect my client. So that's first and foremost. So again, the issue that I spoke about off the record was caused by their late disclosure of a report that was generated over a year ago by their lead detective in this case. That Mr.
They said, whoops, we forgot.
Wants everyone to believe he just stumbled upon 3 days ago. He just stumbled upon 3 days ago.
You don't have to whisper, just talk.
Try to get that middle ground there.
Just talk in a normal tone of voice.
That he just stumbled upon 3 days ago. He made all these accusations about that's disingenuous. I don't believe it. Well, I don't believe that they just found that report from their lead detective who they interacted on a daily basis in this case 3 days ago. I don't believe it. That was done in January 2020.
I already made findings.
I understand.
In my view, nothing nefarious.
What's
I
up,
don't want to go over things that we've already gone over.
Well, we just did. We still haven't done it.
He's asking that that both sides be directed not to make comments to the press. That's what he's asking for now.
I want Rolly to get on this
I'm
thing.
not accusing anybody of any unethical conduct. Let's just move forward. Here's what I want to
I
happen.
have more things.
Oh, go ahead.
All right, I just listened to
Go.
Now, we've heard a little about the discovery issues about, this not being enough. I mean, I think this is incredibly detailed when it comes to Mr. Phillips, especially because of the videotape. This is really detailed. Tell us what he's going to observe at the scene, what he's going to testify to, what he observed at the scene. Putting that aside.
Based on what I've heard, I am satisfied, under the circumstances, that both sides have satisfied this discovery rules. So there's no reason to go over about whether you have complied with discovery. I already found that you did.
Okay, now I want to talk about Ben. There was a police officer, the first one out of the box, Sergeant Zizzo.
Right.
The only thing we have from them, because, I assume the rules apply to both sides, right? The only thing we have from them is a two-line email saying we spoke to him on Wednesday. He testified Friday, recall. We spoke to him on Wednesday, and Jack, you have the email?
All right, y'all give me 1 second. I'll be right back. Here we go.
Here's what we have from them on Officer Zizzo. That they spoke to him on Wednesday, which the officer denied on the witness stand, by the way. He said the first time he spoke to him on substance was the day of his testimony. He said that he advised the district attorney that he responded to the shooting while on patrol, and it's common occurrence that the receiver called a shooting and responded only either to find no evidence or the victim, but also sometimes find out whoever called was intentionally misrepresenting. 2 sentences. That's the discovery. He testified that 1, he may have missed the bullet casings, and 2, he didn't know where to look. 2 sort of important things and he didn't agree, he didn't search the entire street. That was not in their disclosure. Not their disclosure at all. But yet I'm being accused of not giving them the right information. First of all, I don't have the date. There's nothing in their disclosure that they interviewed him Friday before his testimony. We don't even have that interview. We don't have that date. We have Wednesday only. The witness said, no, I didn't speak to him on Wednesday or substance. That was just about logistics. Okay, so before we start casting aspersions, I was going to even raise it, Mark. Just happen. I understand this is trial. But, being that we're now throwing stones, let's hold the kettle black.
Let's not throw stones.
Well, I know, but they started. So I'm going to respond.
This is a no squabbling zone.
Oh, after he swallows. Well, I'm swallowing back.
Well, you're a good squabbler. You're doing a good job squabbling. All right. Regarding what Sergeant Zizzo testified, did he write a report?
He did not write the report, Your Honor. But he obviously was wearing body worn video, which was
That's been provided.
That was provided
All right.
years ago.
You're an experienced attorney. All of you are experienced attorneys. Sometimes, a witness will say something that is not in a report. That's to be expected. A report is a summary, a sum and substance of what the witness said. It's much more fleshed out when the witness is on the stand.
Well, I agree with that. I'm okay with that. I'm not even going to raise the fact that he said he didn't speak to him on Wednesday and he only spoke to him for. I don't do that. It's petty.
It is petty.
But I want to make sure that what's good for the goose is good for the game. That when Mr. Phillips testifies and he says something, a word that's not in this thing, it's not like, you didn't tell that to the lawyers. It's just not right. This is not a transcribed statement. There will be nothing outside the scope of this. But the same way I didn't get anything from them regarding, I may have missed the shell cases. I didn't get a report that said that or a statement.
Again, to be repetitious, I do not find either side has violated any discovery statute or any discovery rule. Regarding the press, the jury has been told not to read or watch anything about this case. I'm going to assume that they follow that rule. But what I am concerned about is someone that the jury knows is going to read or watch something about the case and then relate it to the jury. So, here's the rule. I don't want any attorney in this case saying anything to the press while the case is going on. That's it. So you can call it a gag order.
We will advise, obviously, courts where we've said nothing. We will advise the DA as well. To be clear, the DA responded to Mr. Tacopina's published report where he dared, quote, Nathan Hockman can try the case himself. But we're going to tell the DA.
Let's move forward. Yeah, just let everybody know in your office who may say something. Tell them not to say anything to the media or the press.
Will do, Your Honor. We had two last issues which are brief. The first issue is...
So this is something that we kind of skipped over and didn't address when we were watching it live. The judge said they ain't talking to the media at all, which I think is fair. I mean, we can see the court proceedings, especially if we weren't allowed to be in the court, and maybe that would be one thing, but we could see everything that's happened here. We don't need to hear them talk about how frustrated they are. I mean, it's good for content, but at the end of the day, just to keep everything fair, just no talking. Shut up. Do your job. I don't have a problem with it.
Counsel and I've tried many cases from the court. If there's anything even close,
And they're not back yet, y'all.
If there's any evidentiary issue, which is even a close call, in terms of the defense introducing, bringing up, asking questions, we want to make sure that they ask an approach and that we 402. We don't want to be in a position to have to unring the bell.
That goes for both sides.
Finally, Your Honor, the court is aware. On Friday, it doesn't really matter what the circumstances were. Mr. Tacopina literally started screaming at me.
Here we go again.
So again, Your Honor, I have not interrupted Mr. Tacopina's line. As I see, Mr. Tacopina...
That's not true.
Noises, again, if there's got to be a certain decorum, we're following it. But, you can't bring a knife...
Shout out to ASAP Crybaby.
As the court is respectfully instructed, there were one lawyer talking, the other lawyer not interrupted. Mr. Tacopina, as court is aware, started literally screaming at me in the courtroom. He basically appeared to challenge me to a fight. And again, I've been doing this longer than he has. I've not had...
You don't want any of that, John.
I am not going to be treated that way by anybody. I'm certainly not going to be treated that way in a court where I practiced for more than 30 years and in front of a judge I deeply respect. He doesn't have to like me, he doesn't have to get along with me, but he cannot be screaming at me, whether on or off the record. The court was here. The court, everyone heard and saw it. It's not right. So I'm just asking that the court again,
We did not hear that.
That the court advise
and you are both of you are
Bugging my guy.
zealous attorneys, aggressive attorneys, both of you are.
We are true to zealous aggressiveness. The court has not heard me yell or scream at anybody. And again, and it's not a request. I'm not going to take that.
All right. Why don't we do this? I did not hear you yell. I did not hear it.
'Cause he didn't.
If it did happen, it wasn't in my presence.
That's crazy.
Because you two have this relationship. Why don't you not talk to each other unless it's on the record?
Oh, that's.
And then I am involved.
That train is sailed. Yes, absolutely, I agree with that. But I want to respond.
He said that train is sailed.
I have always one way he makes a record, disparaging remarks, and then I got to sit here. So no one screamed. You were right there, Your Honor. What's happened, and Mr. Siegel was with me, is Mr. Lewin comes up with his little scolding, sort of bullying attitude, telling me we don't know the rules here and we're not doing this right, and he didn't like the opening statement and so on and so forth. So I responded. I don't need a lecture from him. Okay? I'm not going to go into the amount of phone calls I got regarding him and his reputation before this trial started, from lawyers I don't even know, including lawyers inside the district attorney's office currently. Okay? I'm not going to go into it, Your Honor. I'm not petty.
No, and now you're interrupting him. Just that you were complaining about him interrupting you. You're interrupting him. Don't.
Come on, guys.
I just don't want to do that. But please, there was no one yelling. You were right here. There was an argument between both
Passive
sides.
aggressive versus aggressive aggressive.
I'm not going to speak to him off the record. So you're right.
Yeah, this is wild, man.
Number two.
They're adults.
I have to also raise an issue, and I'm not past that. I don't want to even talk about that anymore. Your Honor's here. That's the end of that. Mr. Lewin did something last week that was inappropriate. And the reason I'm raising it is because I don't want it to happen again.
Oh, here it
This
goes.
week-
This is the part we were talking about.
Mr. Mayor's significant other may appear here. Last week, Mr. Lewin has his playbook apparently, one of the lawyers, went up to my client's family and told my client's family that's not personal, but they should really, hopefully he's really thought about taking a plea because she was facing a lot of jail time, and saying things that played on the emotions of the family. He should have no communication with the defendant's family. I've heard he's done that in every case. That's right here. Well, I don't want him, and I want the court to instruct him not to communicate with anyone on this side of the fence. Not the client's family. Not
See,
the
that's
client's
nasty
friends,
work.
because it's inappropriate.
So, Your Honor, what happened was I walked up very kindly to the defendant's mother and sister, and I said the following: "Listen, I'm very sorry because you're not."
That's definitely passive aggressive, yeah.
Myself, I consider myself. I know this is difficult. It's not personal. And I'm truly sorry for what you are having to endure.
All right.
And then I said as follows: I hope that your brother and your son, I hope that he's really evaluated what he is risking here, because he is a lot.
All right. There's nothing that prohibits.
At the time.
I've heard enough. I've heard
Okay.
enough. There's nothing that prohibits what Mr. Lewin did. You've heard now that the defense does not want you to approach anyone from that side, so don't approach anyone from that side. It's as simple as that.
Yeah, he's nasty.
Your Honor, okay. There's just one evidence.
Should not be talking to a family.
Another one?
Yeah, unfortunately,
What is
and
it?
Mr. Lewin bring up
What is
four or two every moment. I just want the record clear on this.
What is it?
It's that the defense doesn't need to preview our impeachment material on an eliminate motion. Mr. Lewin keeps saying we need to bring it to the court's attention or his attention when we plan on introducing or using evidence so that he can have a 402 hearing. The law is crystal clear. If I don't need to go further, I won't. We're on the same page. But the law is crystal clear that there's no rule of law that would require the defense to disclose evidence gathered by an investigator who may tentatively be called by the defense for impeachment purposes. That's Hubbard versus Superior Court. I'll continue. People versus Hunter. Section 105, 4.3, subdivision A1 provides that the quote, defendant and his or her attorney shall disclose to the prosecuting attorney his or her intended witnesses together with any relevant written or recorded statements of those persons or reports of the statements of those persons, which we've complied with. But the court goes on, but that does not include impeachment statements. All right, go ahead. But that does not include impeachment statements a defendant obtains from prosecution witnesses. The prosecutor is not entitled to statements impeaching prosecution witnesses. That's People versus Hunter. People versus Sloan. Here, the defense, the court noted, could use the messages on the tape to impeach a witness without disclosing the tape to the prosecution. The prosecutor was wrong that using the tape for impeachment was the same as introducing it into evidence. A few more cases. People versus Ledesma. The court noted, to the extent the evidence at issue was submitted to impeach, counsel may have been unwilling to give the prosecution the benefit of a preview of the defense case in order to obtain such rulings, which is what apparently Mr. Lewin is seeking to do now, but the court noted that the defense was appropriate in the way it proceeded. Two more. Izaga versus Superior Court.
This is Izaga, yes.
Right. The defense is
What's
not
good, Teresa?
required to disclose any statements it obtains from prosecution witnesses it may use to refute the prosecution's case during cross-examination.
And you're going to mention Phillips.
I'm going to mention Morrison, in which the court noted, nor did the discovery statutes obligate counsel to disclose she would impeach a witness with evidence of prior misconduct, particularly in that case, gun possession. Now, I understand, Your Honor, that the prosecution here wants us to do their homework for them, but the law doesn't require us to. For that matter, all of the impeachment material that we have arises from their own discovery.
All right, let me tell you my view on impeachment. I'm aware of Izaga, but that's a California Supreme Court case. There's another California Supreme Court case that's called People versus Tillis, T-I-L-L-I-S. Both of them say the same thing. Impeachment evidence does not have to be
we're still waiting.
Impeachment witnesses, once the decision has been made to call them, does have to be disclosed. But the evidence does not.
Very good.
All right, we are at 5 minutes to go. I don't want the jury to wait, so let's give Kathy a break, and if anybody wants to use the facilities, they can. I want to get started right at 10:30.
Right, I just have one thing before we wait for Sid, just logistics.
What's logistics?
He wanted to get started at 10:30. They're about 30 minutes late right now. So we're still taking another break, or they're still taking their break. He said he wanted to start right at 10:30. Well, that didn't happen. Let me see if we've had any change on should ASAP Rocky testify. 63% of y'all are saying no. And 37% of you are saying yes. All right, for those of you who said no, let me know in the chat why y'all don't think Rocky should testify. I've already gave my opinion on if he should testify and why he should or shouldn't. But Rice Street said that's your 10:30. Yeah, hey, I've been doing good, Rice Street. I made a promise I was gonna be here on time, and I've been here on time. It's a California 5 to 10 minute break. Yeah, no, not even close. They're still not there. The whiny prosecutor is a problem for the state's case. He will be a distraction from what matters in this case. Yeah, he's pulling all the stuff that they were talking about Miss Love doing in the YSL trial. Over there leaning back when she's upset, looking around, making gestures. During Joe Tacopina's entire opening statement, this guy was squirming, moving around, laughing, looking over here, objecting. It was just super disrespectful. And you said, LTO said no, he should not testify because the prosecutor is going to push buttons. His attorney is doing a good job. If he wasn't doing his job, then maybe. He's paying his attorney to speak for him, plus the state wants to destroy him. I agree with that one. I think there is enough information to prove beyond a reasonable doubt. I would agree with that. Does the jury look at that? The lawyer's actions, they're sitting right next to where the jury is. So they could see him the whole time, leaning back, laughing, like shaking his head, putting his hands in his head, objecting. Wait till the evidence come out. This jury's going to be like, what is this? He doesn't need to. The evidence does the testifying for him. The other guy is testifying for Rocky. Rocky's lawyer will reveal what needs to be told through him. I agree. It's a Glanville break. The jury will be back tomorrow. Oh God, I hope that's not the case. Kathy Rustin over on Law and Crime. She said the 5-minute break is now 45 minutes, which unfortunately is normal in my experience in LA courtrooms. All right, so y'all called it. Jury is about to come in, so we'll be live here shortly. ASAP Rocky should avoid testifying in this trial to minimize self-incrimination, prevent consistencies under cross-examination, and avoid providing additional evidence that could be used against him. You don't want to open any doors, for sure. What else do we have? They were in the judge's chambers. Rappers consider testifying snitching. So like Tory, they care more about being called a rat than their freedom. If Rocky testified, he wouldn't be called a snitch. You can testify in your own trial. Especially when you're being accused of doing something and saying, hey, this is why I did it. Rock, he was already carrying a prop gun, allegedly, right? So he's not going to look like the toughest dude on the block, period. So him testifying, I don't think that would say anything against him, but Relly is, I don't even think Relly's a snitch. Relly is just a opportunist, maybe. To think they had this guy around them for all that time is wild. He shouldn't because his case is cheeks. Okay. Relly's a snitch. People are saying Relly is getting harassed online. Well, you get what you get, man. When you play that game, that's what happens. What exactly happened, if you don't mind me asking? What do you mean, Sharice? Let me see what else y'all are saying. They'll say his attorney's doing a good job. Yeah, Kathy said we should be back shortly. Relly kind of reaps what he sows. I mean, he went after money via text. Did he think it wasn't coming out? Who said ASAP Weasel? Jeez. Man. He should not testify because the jury is going to look at him and judge the credibility of his testimony. And if they prove their case, ASAP Rocky should single-handedly cause it to go south. Oh, cause it. And if they don't prove their case, ASAP Rocky could single-handedly cause it to go south. Will Relly testify through the phone or Zoom? I'm confused. He's in the courtroom right now, so we may actually see him on the stand today. ASAP Relly is snitching. You think so? I don't see. How is Relly snitching? I want to know. Y'all tell me. I don't see it as Relly snitching. I see him as trying extorting, maybe. But snitching, I don't know. Yeah, ASAP Weasel is wild. Aren't these the two who were laughing and carrying on Friday while Joe was doing opening? Yeah, Ryan, that's them. The double standard. These people, I swear, these prosecutors think they're above the law. They think they can do whatever they want to, and as soon as the defense tries to do it, oh, it's a problem. He yelled at me. For real, man? Come on. You said the same could be said for Tory? Ooh, what do you mean by that? Yes, Relly is a snitch. ASAP Bari said it. What about, though? I wonder. He's an opportunist. He's not an opportunist. He's an idiot. Oh my gosh. He's been friends with ASAP Rocky for a long time. This is just per jealousy and greed. I agree. Yeah, didn't Rocky try and find out where he was and threaten him multiple times? Relly isn't a street guy. He's into fashion. I wouldn't consider it snitching. If he was found guilty on all charges, he should file charges on ASAP Relly for extortion, or found not guilty, excuse me. Any defendant that doesn't have to take the stand should not testify. If you aren't putting on a declared affirmative defense that you have to disclose to the court pre-trial, absolutely don't testify. Now, I agree. All right, let's go ahead and get back into it, y'all. Hopefully we get Relly up here. I think Joe's going to finish up his cross-examination of the police officer, the detective that responded to the scene. Was the first one to respond to the scene. And then we'll get into the rest of the testimony. There shouldn't be much left here. Let me see. I'm trying to give us a little bit of a delay. Here we go.
No, I've never met you, sir. Since Friday, have you spoken to anyone about your testimony? I had people ask me about it, but didn't really get into detail. You just speak obviously to the prosecutors. Right? No, sir, we agreed not to in anticipation for that question. There you go. When you say you had people ask you about it, who asked you about it? Co-workers, friends, that sort of thing. Oh, curious. Sure. But you going to it with that now? Again, when you were just arriving at the scene of a call for a shooting, you're looking for victims, right? Correct. Damage to vehicles in this instance. Correct. Shell casings. Correct. Now, we put into evidence defense exhibit A. Can you see that on the screen in front of you? This one doesn't work, but I'll turn. Okay, thanks. Anyway, the street shown there in this video is Vista Del Mar, right? Correct. Okay. And the video starts at the end of Vista Del Mar, closest to Selma, right? Correct. It's right at the intersection. Right. And with the first 15 seconds of that video, you approach a homeless person and ask if he heard a shooting. Do you recall that? I don't independently recall that. Okay. Let's play that.
He doesn't remember anything.
That's their body.
Hey, Val, did you hear any shooting over here? Yeah?
Okay, that's you, right?
Yes.
Hey, pal.
Okay. You were asking. You said, hey, pal, did you hear a shooting over here?
Hey, buddy.
Yes, that was me. Okay. By the way, why was your body cam not on there anymore? I really don't remember. I don't have an answer for that. Your Honor, just for the purpose of going forward here, we have copies of the transcript of this in case we have to refer to that. I have made a copy for the jurors.
Alex, could you distribute the transcripts to all of the jurors? And
Yes, I do, counsel.
does anybody at council table need one of these transcripts?
We'd like to.
We need to
No, I don't think so. That's okay.
No, we got it. Hold on.
You want me to wait to distribute them?
No, distribute.
Yes, sir.
What do you want? This is going to be
B.
B. That's exhibit B.
If there's an extra one, Alex. I don't want to take it from any of you.
Yeah, we can have all right. I don't need that.
All right, Kathy. All right, I'm good with that, Alex. All right. Does anybody not have a transcript?
Yes, take it 1 point down.
Yes, it is.
Let's make sure everybody has a transcript.
Yeah, he doesn't remember anything.
Both sides stipulate that it's audio recorded or video recorded off a video where we have a transcript of the case. We cannot take down what she's hearing.
Actually, the stipulation is not necessary. There's a rule of court that said that when audio tapes are played, the court reporter does not take it down.
I was referring to that rule of court, or that's what I thought.
I just learned that 6 months ago. Yeah, there's no stipulations required. They just don't.
All right, let's keep on moving.
If it was, we would say. Well, good. You got to take
Thank you for that.
For Mr. Jacobina and I.
All right.
No. That'll happen once in a while. So, Sarge, you obviously will look for signs of shooting again. Yes. It's still on. And the video shows multiple officers searching for signs of the shooting on Vista Del Mar, right?
Yes.
Okay. And directing your attention to 22:35 and 54 seconds of that video, the officers are conducting a search using their flashlights aimed at the ground, right? And we'll get you right there. I said 22:35 and 54 seconds. So almost. Anyway, right there. Go ahead, let's go.
Yeah, stop sign, parking lot. Right now? I just said right here. Okay. So what's the make and model?
What's up, Stizzly?
Obviously, everyone has their searchlights out looking for evidence, right?
Yes, sir.
Okay. And obviously, I think this is something you'd agree with, that you wouldn't have wanted to, and none of you would have wanted to overlook important evidence at the scene of the alleged shooting, right?
Correct.
So as careful and attentive an officer, were you a sergeant there as well, or since?
No, sir. I was a police officer 3. I was a training officer.
And then got promoted.
Yes, sir.
Congratulations.
Thank you.
So, as an attentive officer, when performing your duty, you made it obviously a point to be careful and attentive looking for evidence, right?
Yes, sir.
Now, initially you said you thought there were 3 officers at the scene?
Correct, and that was based off of the when my body worn video that we watched.
Right, I understand. No problem. But you agree that there's more now, right?
Oh, yeah, absolutely.
Okay. As a matter of fact, there's 7.
Okay.
Well, you don't take my word. Let's go to the video.
Yeah, Joe knows how to act in front of a jury.
36 seconds.
We'll stipulate, counsel, if that helps as well, that there were 7.
Yes, okay. I just want to consistent with the peak. So, okay. Okay, do you see, would you agree that 7 officers are at the scene?
I don't dispute that there were 7 officers at scene.
Not really dispute, but you would agree that you see 7 officers right there, right? There are 6 in the frame,
Including
the guy wearing the body cam.
Correct, including that one, yes, 7.
7, okay. And everyone, to your knowledge, was doing their job when they were at the scene, correct?
Yes.
Direct your attention to 22:37:03 on that video. That's you on Vista Del Mar on the side of the street closest to the parking lot, right?
Correct.
Okay. And we're looking, by the way, for the record, we're looking south towards Selma Avenue. So you're standing on the west side of the street, right?
Correct. I'm presently facing west in this shot, but yes, this is south in this camera.
And officers are searching that area for evidence of shooting with the flashlights, right?
Yes, sir.
Okay. And that is directly opposite, Sergeant, that orange portion of that wall there, right?
Well, I'm sorry, what's your question?
That where the officers are, right there,
Right.
including you, is directly opposite that orange, whatever that thing is, portion of a wall,
Correct.
right? Which is next to that adjacent lot there, right?
Yes.
A vacant lot, I should say. So that's right across from that orange, whatever, correct?
Correct.
All right. I'd like to show you these 2 photographs. One is that, but we're going to put them juxtaposed and put them right side by side. Okay. The first first one is basically the still frame of what we just looked at. You see the one on the left?
Yes, sir.
Okay. And that's you guys right across from that orange wall, we'll call it?
Correct. Yes.
And then the one on the right, with that single individual there, he appears to be standing in that same exact spot. You also start with that orange wall there as well. We can blow that up a little bit, can we? See that, Sarge? See the orange wall on the other side?
I see orange there. I mean,
Boy,
based
these
off the
videos
photo,
are garbage.
I can't tell much beyond that. I
We'll
see
go back out. There's that vacant lot right there, right?
Right.
You see that?
Yeah, and you know what, the driveway on this side, yeah, I see what you're saying.
So it's basically where that individual is where those offices are, correct?
Approximate, yes, I would say so.
Okay. And so just as we talked earlier about the parking lot where your body cam was, just as in the parking lot, you agree there was no sign of a shooting on the street as well?
Correct.
No blood?
No, sir.
No bullet holes?
No, sir.
No shell casings?
No, sir.
No physical evidence the shooting was recovered at all?
No, sir.
Directing your attention to 22:37 and 29 seconds. We'll play this portion. Go ahead.
We're checking the area. It doesn't look like anybody's been hurt or anything like that.
By the way, for the transcript, what you were anyone to what pages? Sorry. Page 2, line 14 of that transcript, which is Defense Exhibit B, please. I'm sorry, do you have one?
I actually do not.
Oh, okay. So you take a book. Yeah. Sorry, I'll give you this copy. It's here, page 2, line 14. Thank you, sir. Okay. Can we start playing that portion again, maybe go back a few seconds? Okay.
We're checking the area. It doesn't look like anybody's been hurt or anything like that.
Okay. So that's one of your, do you know who that was speaking?
I actually don't.
Okay. Well, one of the officers, right?
Yes.
And you say basically we're checking the area, it doesn't look like anyone got hurt, right?
Correct.
And direct your attention to 22:38, which is basically a minute later, 21 seconds.
I guess it was being thorough because we all know what this shows.
The second PR. Okay, because I got two trends that came up.
This is page 3, Sergeant, and line 4, please. Can you play that portion again, please?
So they were only possible. And we checked every part of the lot. There's nothing, no hits.
Okay. And then a few seconds later, 22:38:40, which, second, I want to make sure we direct the right portion of the transcript. Nice. Okay. Next course I'll direct to the same page, page 3, line 20. So line 20. And now we can play that portion. Go ahead.
Giving you no evidence for now. We can give no evidence.
Okay. So one of the officers, you know who that was speaking, by the way?
I do.
Who's that?
So at the time, Officer John Cook, now Sergeant John Cook.
Sorry, John, okay.
And this is to show that
So now we have no victims, no hits, no evidence.
they wouldn't have missed the shell casings.
Now, directing your attention, directing your attention to 2240-04. Last page.
Volume's low. Candace, I think that's on your side. The volume seems pretty loud on my end. Is the volume good, y'all? They just need to use the microphones. Let me know and I'll turn it up.
And go ahead, you could play that one you're ready.
Yeah, it sounds like someone probably fired a shot in her hair to scare somebody.
Your Honor, we would have an objection on
Hello?
Tuesday. Overall, it's not coming in. Overall, sir.
All right.
And lastly, direct your attention
Should
to
be better now.
40 and 26 seconds, which would be same page 5, line 14, sorry.
Yes, sir.
Okay, go ahead.
Well, no victims as of now, so unless one pops up in the hospital, probably just a warning shot. Okay, you got it.
Okay, and who is that speaking, do you know?
That's also,
Sergeant Cook?
Yes.
John Cook, whatever.
yes.
Again, no victims as of now, unless it pops up in the hospital, it's probably just a warning shot, right?
That's what he said.
And after responding to Greasy Del Mar and Selma Avenue, and carefully searching the scene with your fellow officers, you found no physical evidence of a shooting whatsoever.
That's correct.
And of course, to be clear, that includes no evidence of a shell casing recovery, correct?
Correct, that includes that as well.
Thank you very much for your time.
Yes, sir.
Mr. Lewis, anything? Oh, Mr. Sloman, anything?
Thank you.
Go ahead.
All right, Sergeant.
Yes, sir.
You were asked questions, I believe, on Friday of Mr. Tacopina about your conversations with the DAs on this case. Is that something that customarily happens prior to your testifying?
Yes, it is in every case.
And this incident specifically happened approximately just over 3 years ago, correct?
Correct, yeah.
When you first received a subpoena related to this case, did you immediately know what incident you were even called to testify about?
Absolutely not, no.
Was it of assistance to you in refreshing your memory to be directed to your body-worn video from this specific incident?
Absolutely, yes.
There were no other witnesses.
In his questioning on Friday and also today, Mr. Tacopina asked you questions about searching for shell casings, I believe is how he phrased them. Are you familiar with the term shells, casings, cartridge cases, things like that?
Yes, sir,
What is your personal background, training, and experience as it relates to firearms?
Well, I have the training I received from the Los Angeles Police Department. I've also attended various trainings outside on my own time related to firearms training, different weapon systems, marksmanship, mostly related, that sort of thing.
In the course of that training that you're talking about, have you, can you even estimate how many rounds of ammunition you fired?
I cannot.
That's a lot.
Yeah, that's crazy.
Right.
Okay.
Over the years, yes.
Are you familiar with, just in general, with handguns, the difference between a revolver and a semi-automatic pistol?
I am, yes.
And in very broad terms, what is the difference between those two types of guns?
Well, I think the biggest distinction would be that a revolver operates from a rotating cylinder where it has each individual chambers, usually typically 5 or 6 chambers, where each round, the bullet, sits inside the individual chambers. And when the trigger is pressed to the rear, the cylinder rotates, hammer comes back, strikes the round, discharges the round. Then it continues to rotate. The difference between that and a semi-automatic pistol is all of those rounds are contained in a magazine, and it's magazine fed, so there is no rotating cylinder.
Oh my
Revolvers
gosh.
do not eject those casings the same way a semi-automatic weapon does. Every trigger press with a semi-automatic weapon, a shell casing ejects. And with a revolver, it stays within that chamber, continues to rotate until the weapon is empty, and then you manually eject those casings all at once.
So when you were looking for evidence at this scene specifically of cartridge cases being on the ground, that would be in the expectation that a semi-automatic pistol was used, correct?
Correct.
Because with a semi-automatic, those cartridge cases, once the bullet is fired, come out the side of the gun.
Correct, with every press of the trigger.
Okay. And is that true of all semi-automatic handguns? That's how they operate?
Yes.
Have you personally fired semi-automatic handguns?
Yes, I have.
When you fire, just in your own personal experience, when you fire a semi-automatic handgun, do those cartridge cases always come out in exactly the same trajectory, or do they kind of have a tendency to go in different directions?
The different directions.
Okay. And is it those discarded or used cartridge cases that you would have been looking for that night?
Those are the same ones we're talking about, yes.
Right. All right. Just to put a fine point on that, when you searched that entire area, the street, the parking lot, you didn't find any cartridge cases anywhere.
No, I didn't.
And none of your 6 other partners who responded there with you observed or recovered any either, correct?
That's also correct.
You were asked questions, or I'm sorry, this, I think you were directed to the transcripts, about page 3, lines 4 and 5, where one of your partners says that he checked every car in the lot and there's nothing, no hits, correct?
Correct.
In your experience responding to crime scenes throughout your entire career where a gun has been
Joe's a beast.
what are the types of damage that you would look for on a car, specifically related to a shooting call?
Sure, so flat tires, glass that's been spiderwebbed, right, or totally blown out, impacts to sides of doors or ricochets off of hoods. These are things that I'm just recalling from recent observations, those sorts of observations.
Are some of those observations easier to see than others?
Yes, absolutely.
Can you describe that for the jury?
Well, I think the best way to illustrate that is you have a white 4-door vehicle. It's easy to see the impact where the paint is missing and the metal is bent and distorted. Whereas if you have a vehicle with a darker colored paint job, you might miss it, right? You might not see it. It might blend in.
But also, even more generally, if a window is shattered, you're going to see a large shatter in that window, potentially.
Right, it's hard to miss.
And if a tire is flat, that's easier to see too, correct?
Yes, it is.
Versus, and I want you to assume for purposes of this that we're talking about the hole from a 9mm chambered round. If you observed a bullet hole in either plastic or metal of a car from a 9mm round, that would be a lot smaller, correct?
Comparatively speaking to other larger rounds, yes.
And even comparatively speaking to if the 9mm hit glass or a tire, correct?
Correct.
If a firearm was fired in a downward trajectory and struck the ground, would you expect the round would either ricochet
So they're saying it's
into the
fragments?
bottom of the car, or potentially fragment into bullet fragments that would then strike the car?
I think both of those scenarios are possible.
Okay. Did you and your partners check the bottoms of cars?
No, we didn't.
And in fact, to this point of any damage on the cars, were you or any of your partners, to your knowledge at that scene, familiar with the condition of any of those cars before you responded?
No, we weren't.
So you don't know if any of those cars already had any damage on them?
That's correct, yeah.
Okay. need that video.
I didn't hear what he said either.
Do you have it on a DVD or?
Yeah, we can do it.
I can do it. I can do it on my computer. Yeah.
Come on, get it together.
Sergeant, I'm going to show you defense A. I have the video paused. We've been referring to the timestamp in the upper right-hand corner at 22:38:43. Can you see that on the screen?
Yes, sir.
Just to orient the jury as far as where we're looking at here, would you agree the street on the far right of the screen would be Selma, correct?
Correct. That's Selma that runs east to west.
And then we can just barely see a stop sign. And there's a kind of street directly in front of the officer who's shooting this video, correct? And that would be Vista Del Mar.
Correct. That's Vista Del Mar.
Okay. I want to direct your attention to the handicap parking stalls there. Would you agree that the one closest to the stop sign does not have a car parked in it?
Correct.
He said the empty toilet paper roll suit that he's got on. Oh my god.
One second.
Hey.
My apologies, Sergeant. Marked it on the transcript, but I'm not sure where that corresponds to on the video. One second.
Have you looked at the corner over there? Nobody was trying this down or anything? A bunch of people. So, that's one positive in the hospital. Probably just a warning shot. Yeah, you got it, sir.
Sergeant, I can replay this section, but can you hear what sounds like a crowd of people in the background of this video? I'm going to play it starting at 22:40:41. I'll play it forward for a few seconds.
Okay.
Do you hear a number of people's voices in the background? Not officers.
Right, it's distant, but yes.
Okay. Was this a busy area of Hollywood?
Oh, absolutely, yes.
Okay. Those noises that we hear, would that just kind of be people in the surrounding areas out on Saturday night?
Correct.
What's the point?
Just sort of. Let's go to 223708, please, on that same video. Sorry, just take it. There's a famous orange wall over there. You see that thing on the left?
Yes, sir.
All right. And right across where you guys were searching, where that individual was before, right across there.
Correct.
There's cars right next to that, right?
Correct.
Okay, there's a bunch of cars on the other side of that orange wall, right?
The rider vans here?
Yeah. Yes, there's cars on the other side, I'm saying, of that orange wall, across the street where the officers are.
Right, correct.
Yes, you see those?
Yes.
Okay. And, okay, you could scoot around if you want. Or,
No.
we're done. So you talked about things that you're looking for, flat tires in the car, or broken glass, right? Those
Yes, sir.
two. Impacts on side doors.
Yes, sir.
In any event, you found none of that, right?
That's correct.
And by the way, you never received a report of a complaint at any point in this case that a car was damaged, did you?
At the time when I was at scene, I didn't know.
Okay. At any time after, did you become aware?
If somebody had reported it,
Yeah.
unless I handled it myself, I wouldn't have knowledge of it, right, if it was after the fact.
And one last thing, a Glock is one of those semi-automatics that does in fact eject shell cases, right?
Correct, it's a striker fire weapon, yes.
Interesting.
All right, Sergeant Zizzo, thank you. Thanks for coming back today. Who's the next witness?
My next witness is Leah Ronnie.
We might not get Rolly today. We got someone, he said Leah? Who's this?
Oh, let me mention to you about tomorrow. One of the people involved has a commitment that cannot be avoided. So we're going to start a little early, and we're going to go a little longer. We're going to go 10 to 12:30, but that's going to be it. And then we'll break about 11:15. So
Nice.
Be here tomorrow at 10, and then you'll be excused for the day at 12:30. The following day, normal schedule, 10:30 to noon, 1:30. Okay?
What do y'all think so far?
You don't mind just raising your arm? Yeah. You don't mind just raising your right hand for us, please? Thank you. You solemnly state the testimony you may give at the cause and not before this court should be the truth, the whole truth, and nothing but the truth, so help you God. Yes. Thank you. Please take a seat on the witness stand there. And please adjust the microphone and state and spell your name for the record.
Leah Elizabeth Martin Brown.
Okay, you're allowed. You need to raise up your voice.
Sorry. Leah Elizabeth Martin Brown.
Please spell your name for us.
LeahElizabeth.
Oh, this is the one that made the phone call. Called the police.
MARTIN-Brown, common spelling.
Thank you.
All right, Mr. President, go ahead.
Good morning, this is Martin Brown. Are you, as you sit here right now, are you nervous?
Yes.
have you ever testified before?
No.
This is an uncomfortable feeling.
Yes.
All right.
Who cares? Like, come on.
On Saturday, November 6th of 2021, were you living or were you in an apartment at 1600 Vine Street in Hollywood?
Yes.
I'm going to show you. Turn off the TV.
He's Australian. No doubt she's Australian. Where's Stephen G at? Where's my guy Stephen G? He's from Australia.
There's something that pushed up there that should work. All C's. I'm also gonna, if you don't mind, I'm gonna reach over and just see if I can turn this on. There you go.
And what exhibit are you showing us?
This is People's Exhibit 1, Your Honor, the map. Ms. Martin Brown showing you what I marked as People's Exhibit 1. I'm going to direct your attention towards the bottom. You recognize the area that's depicted in that map?
Yes.
And is the apartment that you were at that evening depicted on this map?
Yes.
Can you point to it for us on the screen behind you? And there should be a stick. Okay. All right, and so she's pointing to the northwest corner of Argyle and Selma. The apartment that you were in that evening, did it have either an exterior facing window or a patio area?
Both.
And what street did those windows look out on?
Argyle and then also Selma.
So from the window, you could see the corner of Argyle and Selma?
I could see pretty much all of Argyle and then up until like Selma in the back of Davy Wayne's, which is a club along there.
Where would Davy Wayne's be?
Around here-ish.
Okay, so you're pointing
Y'all are
all the way to
crazy.
the corner of El Centro and Selma, correct?
Yeah.
Was the apartment that you were in, what floor was that on?
The 7th, it was apartment 701.
Okay. So from the 7th floor, you're high enough that you can see over the buildings that are at the northeast corner of Argyle and Selma, correct?
Sorry to interrupt. Well, ask the court, please. Mind the leading a little bit right there.
Yeah, people's position is it sounds.
He said he's leading.
About the last question.
So, read the last question. Please.
Okay, so from the 7th floor, you're up high enough that you can see over the buildings that are at the northeast corner of Argyle and Selma, correct?
Sustain.
Okay. If I could mark my next exhibit, Your Honor.
6.
Equal 6. One-page document with a single photograph. Appears to depict the corner of Argyle and Selma. Showing you what I just marked as People 6. Do you recognize that street corner?
Yes.
And do you see the building that you were living in this photograph?
Yes.
Can you point to it for us? All right, I'm going to zoom in. You're pointing to the building on the far left of the screen. If I can. All right. The apartment that you were living in,
Y'all are critical.
in that building, was it?
Give him a break.
I'm pointing to the exact balcony.
Oh, you are? Okay.
Yeah. This here.
How do you want to describe that? So I would say in the photograph, there are a number of... Let's see.
Why don't you bring it up to her, let her circle,
I can do that.
and then put it on the projector.
That's good. Thank you.
Thank you, Your Honor, for helping. Yeah, don't start helping the prosecution, Your Honor. They'll cook you over here. This shit is crazy.
Okay. Putting people 6 back up. The black mark that you made here is the exact document you're talking about, correct? Now, it appears that directly across the street from the building that you were living in, there's a number of buildings on this corner of Argyle and Summer, correct?
Correct.
From your vantage point, could you see over those buildings?
Yes.
Taking you back to People's One, you said you were able to see all the way to Selma and El Centro?
Yes.
That night, so November 6, 2021, at approximately 10:18 p.m., did you call 911?
Yes.
Why did you call 911 that night?
I thought someone had been hurt and I wanted to make sure an ambulance came.
How was it that you thought someone had been hurt?
I saw an altercation and it appeared that there may have been a gun involved. So I thought if someone was hurt, I didn't want them to die, if that had been the case. But again, I was on the 7th floor. So.
How many people were involved in the altercation that you're talking about?
3.
Where was the first place that you saw those 3 people, if you remember?
Walking down Argyle.
When you say walking down Argyle, what street would they have been walking towards?
Selma.
And how far up Argyle, so away from Selma, did you see them? Was there some point of reference that you have?
The parking garage that leads into the El Centro apartments.
Okay. Might be difficult to see here on People's 6, but do you see the entrance to the parking garage in this photograph?
Sort of.
Where is it that you sort of see that?
It was a little further up here.
Okay. There's a red
indicating on the right-hand side of the photo, halfway up after the first set of cars on the right-hand side of the street.
There's a red sign here.
Don't do that, Unita. Oh my gosh.
Vertical. Do you know, does that sign say, if you could read the full thing, does it say parking?
I believe it does, yes.
And would that essentially be the entrance to the parking lot?
Yes.
Maybe a little past that?
It was a little further, not that. But
Okay.
yes.
Thank you. What was the first thing that you observed between the interaction of those people that you described?
Again, it was like I was on a 7th floor balcony. It appeared that they were arguing, and they kind of ducked under the parking structure roof, and there was like some loud yelling, and then they appeared to be fine, but went around the corner into the back parking lot, and then that's where it appeared that there was another kind of issue, and there appeared to be like allegedly a gun drawn, and someone appeared to be shot.
Okay. I want to start at the parking garage. You said you saw these 3 people arguing outside of the garage. Did you see a firearm at all while they were outside of the garage?
I was on the 7th floor.
I understand your perspective. From the 7th floor, did you see anything that
Not at that
resembled?
time.
Okay. So the only thing that you observed from the area right in front of the parking garage was arguing? Is that what you're saying?
They seemed to go sort of underneath the roof. There may have been like something physical, but it was obscured by predominantly it was obscured by the roof.
Did you see any physical contact between those men?
Very briefly before underneath, but again, I don't want to
Saying a lot.
that any further.
Thank you. And I'm not asking you to speculate on anything that you're saying happened when you couldn't see them, but from the point that you could see them, what physical contact was it that you saw?
Someone appeared to grab someone.
Were there any, where on the
She was just
person
looking
who
out the
grabbed,
window.
where on their body were they grabbed?
I'm not sure, I was too far away.
Did you see any punches thrown or anything like that?
I said what I saw.
Okay.
Don't really.
Thank you. You saw one person grabbed, and then they...
And then they kind of went underneath it, like there's like a roof thing that obscured things.
All right. Fair to say while they were under this roof or overhang, you couldn't see them, correct?
Correct.
When you next
She
saw
just
any
appeared
of the
to see
individuals
something
involved in
appearing.
that scuffle, where was that person going?
The three of them appeared to, again, I couldn't identify who was who. They just all looked like equal to me. I just saw them all in a group walking towards Selma.
Were all three?
Oh man, y'all are gonna hate me for this, but I gotta go. Time's up. Shout out to the Aussie. Oi, oi, oi. Gotta get out of here. So what I'll do is we'll start early like we did yesterday. We'll review the rest of this. Hopefully they don't get the rally because I'm gonna be sad that I missed it. But y'all know we will be back tomorrow. We're not gonna miss a beat. Depending on how much testimony we get through today, I may start super early. So we might start at 9:30. We might start at 10:30. Either way, we'll be back at it tomorrow. I'm sorry, y'all. I know. But appreciate everyone who's in here. Thank you to everyone who liked the video. Make sure y'all subscribe and hit the notification bell on your way out. We'll finish this testimony up tomorrow, and then we'll go live from court. I guess they're starting at 10, which will be noon. So we'll probably be here at 9:30. Either way, y'all have a great rest of your afternoon. Appreciate y'all. And as always, y'all know what to do. Keep growing, keep pushing, keep it classy. I will see y'all here tomorrow. Peace.